That's fine. Now you can go on, and then we'll start immediately, because I know many guys want to contribute, and we'll try to accommodate as many as we can. So Noah, please go on.
Good evening, everybody. My name is Noah. I'm happy to be back here once more. So I hope today we are all prepared, both as the tutors and the students. So we are also ready on our part. So I hope we will all cooperate and use the name and time. Now, my one prayer is, when we are asking these questions to you, at least let's just make an assumption that we are physically present before the panel, and that there are certain questions that we direct to you that actually happen to us. So especially me, when I'm asking you a question, just pretend we are in that panel you are seeing us there. Because I have certain different questions that I see how you interact when I ask this question.
That's a good question. I couldn't hear him very well. Is it me, or does the same apply to everyone?
We couldn't actually hear. Like you're so far.
We can't hear you very well. Maybe you could sort out your network connectivity.
Excuse me, Solanka.
Yeah.
Sorry, my name is Sophie.
Yeah.
I had a question. When you apply for an extension for the injunction or for the interim orders, so for the injunction,
yes.
Are you given a further 12 months? And for the interim orders, are you given a further 14 days, or it's when there's an extension, it's for a shorter period of time than the initial injunction or interim orders?
Well, thank you for that question. So, normally, if you look at these applications, the way they're drafted, in the orders, in the notice of motion application, they state that, take notice, blah, 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 that the plaintiff or applicant will be heard on this day for the following orders. One, that pending the hearing and determination of this suit, this honorable court do issue or do restrain the defendants from doing this and this and this. So the wording of that is for pending, the wording of that is pending, like the injunction is for pending the hearing and determination of the suit. But you see, I came across case law that says it doesn't matter the wording. Order 40, the provision is under Order 40, Rule 6 of the Civil Procedure Rules, that injunctions shall lapse after 12 months. Maybe you can check Order 40, Rule 6 of the Civil Procedure Rules. Shall lapse after 12 months. Now, if you seek for an extension, the injunctions will lapse after another 12 months. So, provided you just need to continuously renew them. All interlocutory injunctions have to be okay. They say that the advocate has to be, or the party who's applying for them has to be, has to make sure that they prosecute their suit in a timely manner and as fast as possible. And that's why that provision is there, Order 40, Rule 6. So after 12 months, file for an extension. After 12 months, file for an extension. But you see, there are circumstances where it reaches to a point where the court notes that, and I read this in a case law, I'll get you the judgment, where the court notes that, this thing, it's kind of prejudicing the other party and will actually refuse to grant that extension. And it's the honors of the advocate or the party who's applying for them to make sure that they prosecute their matter within 12 months. But normally what the courts will do is just file for an extension after 12 months. If you don't, they lapse and maybe against the best interest of your client. That thing has also been provided for in Alan Gishue's book, Pleadings Without Tears, The Art and Strategy of Litigation. It's well expounded on that. Have I answered your question sufficiently?
Yes, you have, Solanka. Thank you so much.
Okay. I see Alex is raising his hand. Alex, please go on.
Yes, Solanka. Good evening, everyone. So just to add to what Solonka was saying about injunctions, there are two extensions. Usually there may be two extensions. The first one is usually go to court under a certificate of urgency if you want an injunction. Let's say, for example, you have built land somewhere, you have built a house somewhere on a land which is contested, and somebody has gone and they are trying to, maybe the county government probably of Nairobi is trying to demolish your house. So you rush to court, you get an injunction, you come and serve the people, those officials, and say that I have an injunction against you demolishing this property. So it's usually an ex parte injunction. So you've got a court order giving you orders for injunction, but that order is ex parte. The other part has not been heard, so that the court can determine. Both parties must be heard before the court can make a concrete determination whether to give you that injunction or not. So that is the first. That is the first application. It's usually, when you look at Order 40, you will understand, but I'm just simplifying it for you. So when the court gives you an ex parte injunction, the law says you must serve that order, and you see you cannot file an application for an injunction alone. It's usually with other documents. You have to file, maybe, let's say, a certificate of urgency, a notice of motion, and a supporting affidavit. That's the application. And then you have to have a substantive suit. You cannot file an injunction as a standalone. It have to be accompanied by a substantive suit. So maybe it's a plaint. So it's a plaint which has been accompanied by an application. An application is 3 documents: certificate of urgency, notice of motion, and affidavit in support of the notice of motion. Now let's assume the court. Now, when you went to court, you are not served the other party. If the court listens to you and it determines that you have a prima facie case with a probability of success, it can grant you an injunction on the face of it. But then, once you have been granted that injunction, that order, you must serve the other party with the court order, the application, and all documents within 3 days. If you don't do that within 3 days, Order 40 says the injunction will lapse. That's number one. Number two, once you have served the other party, that order will tell the other party to appear before the court. Pamoja na nini? It's called summons to enter appearance. It will require the other party to enter appearance within, I think it's usually 14 days. So when the other party appears before the court, you see the injunction which you are given by the court first, it's for 14 days pending the inter partes hearing. 14 days pending inter partes hearing. Now when you appear before the court will hear both parties, and then it can decide to extend that order for injunction, which will lapse, as Solanka said, for 12 months. I hope you have understood. So after 12 months, that's when order lapses are extended. So if you go to court after 14 days and the court does not make an order as to whether that injunction suffices, you should ask the court to extend that injunction until inter partes hearing. If that order is not extended, the injunction will lapse. So there are 3 ways in which an injunction can lapse. Number one, if you don't serve the other party within 3 days of the order. Number two, if that order is not extended after 14 days. And number 3, after 12 months, if that order has been extended. I hope you have understood. But when you look at Order 40, you will understand better. But it confuses a lot of people, but I just found it important to clarify. Thanks.
Thanks for that, Alex. That's a very good. You've actually broken it down. So you'll come to do this particular topic in campus, and it really confuses people. That stage when you're applying for injunction, before the suit begins, you've rushed to court. And you need these injunctions even before the parties are heard. So you need, you file an ex parte application. Yeah? Then after the hearing, you need to extend them. There's that one for 14 days, there's that one for 12 months. It usually confuses people. And thank you, Alex, for breaking that down. We have some few questions. Wangari, you can begin, then although I can go on.
I just wanted to ask Solonka, can Alex please type what he had said in the chat about the 3 ways an injunction can lapse? kindly.
Yes. Please, Alex, go on. Can you please type that in the chat box if you are able to?
All the group are okay. I'll just copy paste in all the groups. Oh, thanks.
Okay, no problem. And then, although please go on.
So my question is this: I think is explain about the certificate of agency, notice of motion, and supporting affidavit. All of them going together, and it said you have to have a main pleading, either a plaint or a petition. So at that first instance, when you're approaching the court, do you have to prepare this petition or plaint, or you just go with these three documents to the court?
Now, go on.
Secondly, can the court give like that injunctive relief like less than 12 months, or is it automatic that you will get the 12 months?
Okay, now maybe to begin, okay, let's answer the last question that you've asked. You will get the injunctive orders according to how you've prayed for them. I don't even have a sample application here. Let me just see if we have a sample application. I'll try and get it. It depends with how you've worded it. So the timelines and everything, it depends with how you've worded it. So just to give an example, you will seek for, okay, let me just try and give an example of a notice of motion application. So you've done the heading, then there it's written, take notice that the Honorable Court shall be moved on the day of 2021 at 9 o'clock in the forenoon or soon thereafter, so that the counsel for the plaintiffs / applicants may be heard on an application for the following orders. Now you start listing your orders. The first one, you are doing it under certificate of urgency. So you will say that this application be certified urgent, just keeping it as simple as possible. Then the second bit, that pending hearing and determination of these suits. Pending hearing and determination of this suit. So the way you've worded that specific prayer is that this restraining order or this injunction be granted pending hearing and determination of the suit. Now, there are other circumstances where even pending the hearing of that application, remember, we have the main suit and we have the application. So even pending the hearing of the application, you still need these injunctive orders. So you will state that pending hearing and determination of this application, these are two separate prayers. Pending hearing and determination of this application, this Honorable Court be pleased to issue an injunction against blah, 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 restraining them from, trespassing, disposing, wasting, alienating. Now, the second, that's pending hearing of this application, pending hearing of the suit. So I don't know if you've gotten the difference between the two, pending the hearing of the application and pending the hearing of the suit. Now, the thing is, no matter how much you word, and I read this from a High Court judge, no matter how much you word your application or the prayer in your application, now, for instance, how we worded ours, pending hearing and determination of this suit, injunctions will always lapse after 12 months. After 12 months, automatically. Even if your prayer and the court grants you that prayer stating that, pending hearing and determination of the suit, the injunction has been granted. You have to always file an application to extend those to extend the injunctive relief that you're given. So the timelines depends with how you draft your application and the prayers you're seeking. Now, on the second, the second bit of your question, what was it?
So you see this whole idea of, you can't approach the court unless you have a plaint or a petition. That's not something that's really confuses some of us. The sense that at the first instance you're seeking this injunction, you want an immediate action. So you have those three things I mentioned: notice of motion, certificate of agency, and the supporting affidavit. And that is filing that. Do you file a claim together with that or a petition together? Is there a fourth document involved?
Okay.
So long as you can contribute to that.
Okay, no problem. Let me just 2 minutes, then now you get to that.
Okay.
Just in brief too, although Ahmed, whenever you're filing these applications, whenever you're filing that application, now, for instance, what you're talking about, you always need to have a substantive plaint with it. You always need to have a suit in court when you're filing this application. So you need, if you're coming to court for, you're coming to court and you're filing this thing, you file a certificate of urgency. The essence of a certificate of urgency is for your matter to be certified urgent and to be heard ex parte in the first instance, and for the matter to be heard, for it to be certified urgent and to be heard in a quick manner. Now, other than certificate of urgency, you've also filed a notice of motion application. Now, that's the main application because you're seeking for injunctive relief. How do you move the court? Order 40 of the Civil Procedure Rules provides for injunctions. Now, read together with Order 51 of the Civil Procedure Rules, which provides for applications, the notice of motion being the default application. So, you have to pair it up, and the supporting affidavit, which needs to support your application. Now, whenever you're filing this, it's mandatory for you to file a pleading. Now, for instance, a plaint, you need to file a substantive suit. You need to attach all these documents. So when you're moving to court, you will have the certificate of urgency, the notice of motion, the supporting affidavit, and the substantive pleading. And this is something I saw even in practice where advocates got it wrong. They just go to court and file an application without any substantive pleading before the court. When opposing counsel sees such a mistake, the first thing they will raise is a preliminary objection. It's defective ab initio. Maybe Alex can expound on that. It's something that I interacted with it personally. So you need to have a substantive pleading for the court when you're filing that application. Alex, please go on.
Yes, actually, Solanka has explained it very well that you cannot file. You see, when you're in civil litigation class, there's something that lecturer says. Sana Mongare, he usually say, what are the ways of instituting a suit? What are the ways? That question is very important. What are the ways of instituting a suit? You cannot institute a suit through an application. You can only institute a suit through a pleading. So it's only that the pleadings are accompanied by the application. If it's demolition of a house, the example that I gave, what you need to do is, the thing is, why this house should not be demolished. You are suing, it's you versus the county government of Nairobi because it's the one that's coming to be demolished your house. But now you are seeking an injunction. That's why the real thing is demolition, that these people are infringing your rights or whatever they are doing and whatnot. But this application you are making is for an injunction. So you have to distinguish. You have to know what are pleadings and what are applications. It's only pleadings which institute a suit, not application. So if you want to make an application before the court or to the court, you have to have a substantive pleading which the application is based. Even if it's a petition. See, in Katiro Pitamunya, I think I've run the case versus Dixon Mondagi, then the Supreme Court said if it's a petition, you don't get injunction, you get a conservatory order. So even a petition, it can be accompanied by a notice of motion. If you read the Mutunga rules, rule, I think it's 117 of 2013, those legal notice number 117 of 2013, they say that an application can accompany a petition. Same case with plaints. A plaint, an application can accompany a plaint, but either way, it must be an application must accompany a pleading for it to. Otherwise, just as Solonka has said, it will be struck out for being inappropriate. I hope you have understood.
Defective ab initio. And then that's the question. Actually, even in exams and even CLE, people get this thing very wrong. They draft a question and then they tell you draft the most appropriate pleading. They can't distinguish between an application and a pleading. Those are two different things. Pleadings are defined under Section 2 of the Civil Procedure Act. Applications, you can check the Civil Procedure Rules. There are different types of application. There's a notice of motion. There's a chamber summons. Originating summons can also be an application in particular circumstances and so forth. So it's a mistake that cuts across board. It's not even for students alone, but even practicing advocates do it. So if you file an application without, as Alex just said, you cannot institute a suit using an application. You cannot just say you're moving to court and then file a notice of motion. You've not moved the court. There's no suit in court. Now I'm seeing, although is that fine?
Yeah, Solonka, let me, that's really so helpful. So let me ask one more question related to this, because I'm getting to an aircraft and I will not be able to follow up. I'll probably listen to the recording. Now,
That's fine. That's fine.
Now the issue of the plaints and petition. I read somewhere or heard that if you can address constitutional rights, let me put it this way: if you have a plaint or a petition, first, if you can kind of indicate your right using a plaint, you have to take that as the first option instead of going with a petition. You probably could address that also. In the first instance, is it either or you have to exhaust, like you have to use a plaint first, and then you can go to petition? When you have the two options, can you go with either, or it has to be a plaint first?
Kidogo. Solonka, can I answer that?
Sumaya,
Hello,
please
guys.
go on.
Can you hear me?
Yes, I can hear you. So go on.
Yeah, there's a few things I wanted to say, but let me just answer the question first. Yeah, so in practice, you'll actually come to see that, and now depending on, if you look at the Mutunga rules, there are specific circumstances where petitions are used, right? Also the same to JR, also the same to plaint. So when in practice, you'll come to see that there are specific reasons under which. Sorry, I was saying, yeah, there are specific reasons under which certain pleadings will be used. And okay, so the document I'll share in the group that states usually the circumstances will use certain things. So you'll see for plaints, mostly they're used for commercial issues. In the exams, you'll see in the silly past papers, you'll see questions that have issues with commercial disputes. If you see anything that is basically those kind of disputes are solved with a plaint, right? And then when you come to look at petitions, they deal with either constitutional issues, bankruptcy issues. They deal with, for example, in a petition to become part of the bar, you have to do a petition. So you'll come to see that there are certain instances where you use those applications. So there's no like there's no like way to. How do I put this? In short, you just have to memorize or sort of know exactly when to use certain pleadings. Does that make sense? So you'll come to see with time, you'll get the hang of it. Like, you'll know if it's a commercial dispute, if it's something that has to do with an agreement, if it's something that has to do with an injury, any tortious issues, you go with a plaint. If it's a petition, it's either constitutional issues that have to do with any human rights, it's a bankruptcy proceeding, it's an election proceeding. Those ones are done by petition. And then you'll come to see that things like OS have their own use, things like chamber summons have their own use. So the best thing, what I'd encourage you guys to do is, I mentioned this last time, get a drafting book. And then on your drafting book, on the first page, just list all those reasons, all those circumstances. Yeah, just say for a plaint, these are the circumstances you draft a plaint. For a petition, it's like this. That way it becomes easier. So I hope that answers the question. Something else I wanted to say, you see this, what Solonka and Alex are talking about, most of the time, if you look at the CLE past papers, that they don't really need you to draft the certificate of urgency plus notice of motion plus affidavit and the pleading itself, like the plaint. So be very careful with the question, like read what the question wants to, like really understand the question first. In most cases, I've come to realize that if you see a drafting for a number one question in your exam and it's 20 marks or 30, it's usually 20 or 30, 20 marks, I think, yeah? If you see a question that's worth 20 marks, at least here I'm doing minimum of 3 things. I'm drafting minimum of 3 things. And that is usually either it can either be a plaint and it's, a verifying affidavit, or it can be a defense together with a counterclaim and it's a verifying affidavit, or you'll find that it's a certificate of urgency, notice of motion, and a supporting affidavit. So be careful. So if, for example, you see a question that needs you to do an injunction as number one, it's very rare for them to need you to actually draft the plaint. You see, once you draft the certificate of urgency, notice of motion, and the supporting affidavit, you're good to go. So I just say be careful with the questions, because whatever we do in exam isn't what happens in practice. You see, as Solonka said, in practice, if you don't file your application that has an injunction together with the main suit, then that's grounds for your suit being struck off. But in an exam, you don't have time to draft over 5 or 7 things. You understand? So no one will need you to do a plaint per se when the question is asking for an application. So I hope that helps. And then what I also wanted to say on that note is, when it comes to injunctions, there are 2 things you'll never miss in a proper oral exams or a proper civil litigation paper. You will not miss, number 1, a question that has to do something with injunctions or execution. Sometimes the paper can have both. So if you want to be really good at civil litigation, number 1, make sure you really get to look at the civil procedure rules, but most importantly, make sure you know everything in and out on injunctions and execution. Sana sana, because those are the tricky things people don't usually know, and examiners have known this. What I noticed is when you study the past papers, you will see a trend where if this year they bring a question on execution, like us, our number 1 was a stay on execution, probably it was a stay of execution drafting. Probably this year they can bring something on stay of execution theory. You see, or they can bring something on drafting of an injunction or theory of an injunction. Sawa. So make sure meiva hizo vitu sana. And then for injunctions, don't focus. Okay, it's good to know how to draft them, and it's good to know how to list the grounds and in the prayers, especially the notice of motion. But also, since we're preparing for orals right now, you need to know the theoretical aspects. Most importantly, know the theoretical aspects of injunctions. You have to know the cases, you have to know the grounds under Jela versus Castleman Brown, or the Kenyan version, which is the MRAO case. You have to know those grounds. And most importantly, you need to know these unique types of injunctions. For example, Mareva injunction and Anton Pillar. Please make sure you know those 2 things. Know the circumstances where you use an Anton Pillar and Mareva. Like, what I'll tell you guys is you have hopefully you have so much time till your exams. So for now, till oral exams, try to focus as much as you can on the theory. With the drafting, you can always do drafting after orals. So if you don't know these documents you're mentioning, just write them down somewhere, go look for them later on. But don't stress so much on knowing a lot of the drafting. Make sure you know the theory, because that's what you'll be asked in the oral exam. So make sure you know the theory of all the injunctions. Make sure you know the grounds that you need to raise when you're asking for an injunction, and which is usually what the court considers, when granting the injunction. As Solonka mentioned, please know the timelines where an injunction lasts, if it's an interim injunction or return. Injunction that pending the main suit. Know both of them. And then once you've now read on injunctions, have an idea about execution. Go read Order 22 very well. Like, make sure you know what everything that is there. You make sure you know that the types of execution, how execution can be stayed, what are the grounds during that. And if you haven't done it in class, also feel free to, if you ask an oral scenario, feel free to let the examiner know that you haven't covered this yet, and maybe you can attempt answering the question. Yeah, I hope that helps.
Thank you so much, Sue. Thank you so much, Sue, for that. That's something you'll never miss a question on injunctions. Just make sure you read Order 40 and you know Jela versus Castleman Brown and all those interrelated cases. Now, I can see Noah had his hand up. Now, since Noah, you are one of the guys who's tutoring, let Arunga ask his question, and then afterwards you'll begin. You'll begin from there. You'll answer his question and then say what you have to say. So Arunga, please go on.
Okay, thank you, Mr. Pareno. Mine is a follow-up question. Though I joined a bit late, I don't know if you tackled it. My follow-up question is with regard to a question that somebody posed to you last week concerning professional undertaking. There was that question to do with a professional, where an advocate has given a professional undertaking. Sorry? Yeah, there was I don't know if you can remember, instead of me to rehashing the question. I don't know if you can remember the question.
Yes, I can remember the question. I can remember it. I can remember that question. It was a matter where the bank went under receivership. The advocate had posted the money in the bank account, and he had given an undertaking of the same. So will he be held liable? Is that question, Arunga? I can think of something along those lines. Yes, that was the question, yeah?
Yes.
Okay, go on now in relation to that, yes?
Yeah, I just wanted now to know what were your findings on the same?
Okay, thank you for that. Thank you for that. Now, Noah, to be honest, I didn't do much research on it. I was a bit held up during the week. But I'd want to give my colleagues a chance to say it because as I speak right now, for me, the professional undertakings are.
So Blanca, can you repeat the question?
Okay, so the question was, there's this fact. The fact they had given me was there's an advocate who had given a professional undertaking. Now, when he had given the professional undertaking, I don't know, he deposited the sum of money that he ought to have given in relation to that professional undertaking to a certain bank. Now, that bank went under receivership. The other parties are calling up that undertaking. Will the advocate be liable? Now, taking into consideration the fact that the only reason why he is not able to pay up or to comply with the professional undertaking he had given is because the bank is under receivership. So is the advocate liable? It was an ethics question.
Okay, that's that's an interesting question. Maybe I don't know. Maybe you can just look at it in this sense. Once if you look at professional undertaking generally, and we all know that they're governed by some LSK rules that govern and there's some LSK rules shown on the group that govern undertakings generally. But there are a couple of 12 to 13 rules that generally govern undertakings. And one of them is that undertaking generally is an unequivocal declaration, So once it's issued by the advocate and they say that, pending party A and B depositing certain documents or doing certain things, then I will be liable to give that money. So I think the fact that this bank is receivership is a very generally it's a murky ethical area, but then look at it this way: if the advocate does not go ahead and do what he has promised to do in his undertaking, he can be taken to the advocate's it can be reported in the Complaints Commission and even taken to the disciplinary tribunal, right? So if you look at it that way, then that means, I think ideally, I would look at it in the sense that once you've given the undertaking, come rain or sunshine, as long as you're the advocate and you are in possession of that money, then it is your ethical duty to make sure that money is remitted. How it's remitted and the process of which it will go through to make sure it's taken to the bank that has now gone under receivership is now a commercial law question on on insolvency of companies, right? But generally, as an advocate, once you give your word and that party does the obligations as per the PU, then I think it's definitely an obligation to make sure that money is remitted. So if that question is, I don't know if it's a project question or if it's a group discussion question, look at it generally. The good thing with KSL is that no one really, even in an oral scenario, no one really, and especially when it comes to ethics, no one really cares so much about the answer at the end. It's all about how you analyze the question, right? So if you ask this in an oral exam, start by defining what a professional undertaking is, give a couple of cases. I know there's KCB versus Adala that defines professional undertakings. There's this case by is it Professor? This guy who keeps on going to cases. It's a gender. I think there's a case for gender also as an undertaking. There's so many KCB and NBK cases that have to do with undertakings generally, because banks do a lot of undertakings. So start by defining what a professional undertaking is, an unequivocal declaration, given by an advocate or a member of his staff, that is relied upon by another party. Once you've spoken about that, then talk about the LSK, rules that govern undertakings. For example, undertakings should be number one. Generally, R should be in writing. You can make it. You can do them orally, but LSK encourages advocates to make sure they're in writing. Number two, you have to make sure that that undertaking doesn't have to be in a form of a contract. It will still bind you. If it's in a form of it's given by partners, it will bind the partnership. So there are certain rules and conditions. I'll forward, there's some really good slides I have on undertakings. I'm going to forward them to the group have a look at them. But first of all, do it in that way. Discuss the professional undertaking, discuss the rules that govern, talk about a couple of case laws, then now talk about the importance or what happens when an advocate breaches a professional undertaking. And professional undertakings are very serious things, by the way. In practice, it's very serious. People get sued all the time for breaching them. Some advocates are taken to the Complaints Commission or even sometimes the disciplinary tribunal, for doing that. And generally, advocates are always told to make sure before you give a professional undertaking, make sure you have the finances in your control. Don't give a PU on reliance of a client. Yeah. So I think that's how I'd analyze the situation.
Thanks a lot, Sue, for that. I can also see Alex's hand is up. But now, even before we go to that, there's a case law I got recently. It touched on our firm. It was given, I think, 2 weeks ago. And the judge, Justice Okwani, was very clear. She held that, you're an officer of the court and you're obliged to honor an undertaking. So no matter the excuses you may give, you are obliged to honor an undertaking. And if you don't, it's prima facie evidence of professional misconduct. So far, I will agree with what Sumaya said, and maybe during the last discussion, what we had held. Who's talking?
Yeah, it's William.
William. Okay, William, go on.
Yeah, I think one of the cases, the recent one is the one of Mohammed Mugai Advocates versus Daniel Orenge. And I can just read a paragraph from it. It's a 2020 case.
Yes, please go on.
Mugai. So the judge then says that with due respect to the learned counsel, a professional undertaking is given to an advocate on an authority of his client. It is based on the relationship which exists between the advocate and his client. An advocate who gives such a professional undertaking takes a risk. The risk is his own, and he should not be hard to complain that it is too burdensome and that someone else should shoulder the responsibility. So it goes on and says that a professional undertaking is a bond by an advocate to conduct himself as expected of him by a court. No matter how painful it might be to honor it, the advocate is obliged to honor it. So I don't know if that one can still be one of the precedents used to support.
That's a very good case. It's a very good case. Thanks for that. Maybe I've seen Alex was raising his hand. He maybe had a contribution to that. And then Noah had a contribution, and then Alex. Noah's hand has been raised for long.
Yes, good evening. I hope now I'm clear. Mr. Parene, am I clear now?
Yes, I can hear you very well.
Okay. I agree with Sumaya. And I agree with her totally. So, me personally, I always believe in every rule or every law, there's always a loophole. And there's always a way you can maneuver. I agree that whenever you issue an undertaking, then it is your duty to honor it. However, during my conveyancing studies when I was in campus, when I was studying the other principles of professional undertaking, I realized that one of the principles was that whenever you as an advocate, you are giving an undertaking, and then you realize, for instance, that this particular person will not be able to pay, then it is always your duty as that advocate to notify the client as early as when it becomes clear that that event will not occur. So the moment you fail to notify the recipient of that undertaking, then you will be also been, let's call it professional misconduct. So it is also your duty that if you feel or you see that you are not able to enforce this professional undertaking, then the loophole is kindly notify that client as early as possible. For instance, you have realized that this money is not coming, considering the person who is going to give me that money has gone under receivership. Let me go and inform the client as early as possible when I have realized that these people are going under receivership. So I think that is the small loophole, though it cannot, remedy the situation, but I think it's worth noting, just to add on what Sumaya said. That's what I wanted to contribute. And then earlier question, before the issue of professional undertaking, somebody talked about, issue how to avoid constitutional petition when there are other ways in which you can institute a suit. Yes, during our previous oral mock colleague, Mr. Kamau, talked about constitutional avoidance. I think that's what Ahmed was talking about. So you can use other remedies, other modes of instituting a suit apart from petitions. For instance, I'll give an example. For instance, employment matters. One of the issues that usually arise out of employment matters is the issue of unfair termination of, the contract or employment. Then this is always an issue of Article 41 and 47. But you realize, courts always tell people do not go back to do not rush the ELRC to file a petition where you can solve this issue by way of a memorandum of claim. So I think that was what Ahmed was talking about, issues to do with constitutional avoidance. So, Pareno, that's what I wanted to add.
Thank you for that. Thank you for that. Thank you for that. So we have, who else? Kyoko, you can go on, then Tyson, then Degwa, then Muturi.
Can you hear me?
Yes, I can very well.
Okay, good evening, everyone. This is my first time joining, so I don't know if I will be in order. I'm asking a different question, not under professional undertaking or under injunctions. Mine is on interim orders. I would like to understand when they are used and when they can be extended, because I know I've heard of so many times while working in a firm that I'm supposed to go and extend some interim orders. When am I supposed to extend them, and when do I take them in the first place? Yeah.
Okay, thank you, Kyoko, for that. Now we can take also another question. Then now we answer them. And Tyson. Then we answer the two. And then now we go on. Tyson, please go on.
Hi, guys. Solonka, hi.
Hi, how are you?
I'm fine, thank you. Mine is not a question.
Mm-hmm.
I just wanted to share some 2 sentiments or 3 on the issue of professional undertakings. The guy who asked that question, I think it's more or less tied to the decision in Bila Mwangi and something. It's a law firm that was actively participating in a transaction with AdLife Plaza. I think it's somewhere along Yaya Center. These guys, I think they took a loan from either KCB or something of the sort. I think it's KCB. Then they defaulted in paying back. Then the law firm was saying that it wasn't obligated to pay the balance that was pending. I think it was around 1 million or something. Then they were saying that if any case, the person who is supposed to pay is the AdLife, their client. Then I think the court said that a contract between a client or rather 2 transacting parties and a contract on professional undertakings, those are 2 different issues on very different planes. So the guys were compelled, actually the law firm was compelled to pay that amount. And what maybe I can emphasize is that a professional undertaking is very different from a contract between your client and another party. Your client, in the sense that I, as an advocate, any transaction that is happening between my client and party B doesn't affect the issue of any professional undertaking that I might issue in the circumstances of that transaction. I think if you are in Mr. Dr. Mondi's class, you will hear him always emphasizing that in future, please don't try and take a professional undertaking if you are not certain about the funds. You might run out of funds, but irrespective of you running out of funds, you'll have to pay that professional undertaking. So long as you gave it out unequivocally, you'll have to pay it at some point. So what maybe I can emphasize is that in that case, the only option that is available to the party who has not defaulted, that is party B, he can sue the advocate under Order 52 of the civil procedure rules, and this guy will be compelled to pay the amount. Alternatively, you can also go under this mechanism provided for under the Advocates Act, which is through the SEC, the commission. and cite this guy for professional misconduct because maybe he hasn't honored his professional undertaking. I think that is the much I could weigh in on that one. Thank you.
Thank you for that. Thank you for that. Thank you for that. Now, let me just answer Kyoko so that I don't forget the question. So, Kyoko, I'll answer it by giving simple facts. Simple facts. A client walks into your office. A client walks into your office and tells you, okay, Kyoko, Wakili Kyoko, I am going to be evicted in 48 hours from my house. Kindly assist me. And then gives you a very good case, and you think, this client has a good case and she should not be evicted, maybe for some apparent reasons they're pleading. So what do you do? How will you go about that, Kyoko? The first thing you will do is, you need to safeguard the interests of the client. How do you safeguard the interests of the client? You will need to get temporary orders. You basically need to get an injunction restraining the person who wants to evict her from evicting her. That's what you will do, yeah? But now, remember, there are ways in which you institute a suit. How do you institute a suit? By filing pleadings in court. What is a pleading? A pleading is defined under Section 2 of the Civil Procedure Act. I don't have it here, but you can just check. It lists the types of pleadings. A plaint is a pleading. A plaint is a pleading. A petition is a pleading. There's something known as an originating notice of motion and so forth. You'll find them under Section 2 of the Civil Procedure Act. That's a pleading. That is how you institute a suit in court. A pleading and an application are two totally different things. How will you seek for those? How will you seek for a temporary injunction? You will seek for a temporary injunction by filing an application in court. But then remember, when you're filing an application in court, you cannot institute a suit by an application. So what do you need? You need to file that application and file it together with a pleading. So as to initiate a suit in court. So what will you file in that circumstance? So your client has approached you in the office. Now you tell her, okay, I'll move to court the next day. How many documents will you have? You will have a certificate of urgency. You will have a notice of motion application. Why a notice of motion application? It's provided for under Order 40. Order 40 is on injunction. How do you move the court for an order of injunction? You read Order 40. It provides for a notice of motion application. We will also rely on Order 51 of the Civil Procedure Rules on the basis that it provides that the default application is a notice of motion. So you have a certificate of urgency, you have a notice of motion, and you have a supporting affidavit to support your application. What else will you have? You will have a pleading. Now, a pleading in this circumstance will be, now you will have a plaint. You will file a plaint with that. So a plaint is usually accompanied by certain documentation. You can check Order 3, framing an institution of suits. So plaint, verifying affidavit, witness statement, list of witnesses, and all that. So you have all your documents and you move to court. Now I come now to your question. You've understood now how we instituted the suit. You come now to court. Your application, the orders you're seeking for are that pending hearing and determination of that application. That's the first order you'll be seeking. Okay, the first order will be that this application be certified urgent. The second order will be that pending the hearing and determination of this application. Remember, this is the application for injunction. Pending the hearing and determination of this application, this honorable court grants or this honorable court restrains the defendant from evicting so and so and so, pending the hearing of the application. Now let's start with that. Under that, you're seeking for you're doing that's an ex parte application. The court has not had the other party, but you've moved the court and you've told the court that this person will be evicted within the next 48 hours. I've laid down a prima facie case, and all those things, and there's serious risk of irreparable injury being done. And the court says, okay, you have a good case, and this person, to avoid this person being evicted, I'll grant you the ex parte orders. Now, ex parte orders, if you read Order 40, they are valid only for 14 days. So what do? You've been given the orders. Within 3 days, you need to go and serve the other party. Once you've served the other party, after 14 days now, the court, there will be this thing now. The first one was ex parte. Now there will be an inter partes hearing. Now, after 14 days, you will need to extend those orders. You will need to make an application to extend those orders. And I'll give you a story that was once given by a lecturer after I'm done explaining all this. You will need to extend those orders because they lapse after 14 days. That is the first lapsing we're going to be talking about right now. After 14 days, the ex parte orders you were given will lapse. So at the hearing, you need to do what? You need to extend it. Okay. Now, we go back to our notice of motion application. The second order was that pending hearing and determination of this application. Now, the second prayer you will be seeking for is that pending hearing and determination of this suit. Pending hearing and determination of this suit. Now, you're trying to capture the aspect of the application has already been done. That was an interim order, ex parte orders you're seeking for now. Pending the hearing and determination of this suit, because you see, court in Kenya right now, you may file a suit right now and it may be concluded after 2 years or so. So pending the hearing and determination of this suit, what do you need? You need an injunction to stop these people from doing what? From evicting your client. Now, I also refer you back now to Order 40 Rule 6 of the Civil Procedure Rules. Order 40 Rule 6 of the Civil Procedure Rules is very clear that injunctive orders, the one that you're now going to be given, is valid for only 12 months. After 12 months, they automatically lapse. You need to also file for what? For extension of those orders. Yeah, so that's the second bit where you need to file for an extension of those orders. Now remember, like interim, don't even think of it in a technical or complex sound. Interim basically means temporary, just means temporary. So they're temporary. You need to file for extension in the first instance. If you've been given an ex parte order for 14 days, you need to extend it. Now, if you've been given an injunction and 12 months have lapsed, you also need to file for an extension for those orders to be extended. Because if they are not extended, what will happen to your client? The other parties will be like, the other advocate will be like, this is the thing. The orders lapsed, you can go on ahead and do what? And evict that lady. Now, if she's been evicted, it's going to be a bit hard to bring her back because it's already overtaken by events and so forth. So the best the court can do will be maybe monetary damages. But your client doesn't want monetary damages. She wanted to stay in a house, but now she's been evicted. So those are some of the nitty-gritties under Order 40 Rule 6 that you need to take into consideration. I don't know if it's clear because I tried to just summarize the entire process from when the suit is instituted and so forth. Have you understood how there's a bit I need to clarify more?
Yes, Brian, I think that is clear enough on my end. Thank you.
It's clear. So when you're reading Order 40, you also need to read the following cases. GLR versus Castman Brown. Trust you me, that case will be asked to you. If it's not orals, when you're applying for pupillage, I was asked the questions, the 3 things that you need to satisfy. You also need to read the case of Emrao versus First American Bank. I'll ask one person when we begin the oral mock-ups. We started with so many questions and so forth. So make sure you read Order 40 very well. Read Order 40, read Order 51 and all that. Now, since time is kind of going, let's see. Ndegwa, please ask your question. The first person, please ask your question. Then now we proceed.
Yeah. Hello, everyone.
Okay. Hello.
Yeah, this is my first session, and so far so good. So my question is, I've heard about what we refer as a perpetual injunction. So what is the place of a perpetual injunction vis-a-vis Order 40 Rule 6, as you said that it lapses after 12 months?
Thank you for that. Now, so that we save on time, I'll need to get all the questions. I'm writing them down. And then once we have them, we close the questions. Then now after we answer them, we start the oral mock-ups because no time is going and so forth. So I'll take the next question. There is the other Ndegwa who wanted to ask a question. Please go on.
Yeah, thank you. A follow-up question. What was the name of that Mohammed Muigai case for the professional undertaking?
I think Quinta posted it on the chat box. Let me try and see.
The chat box,
type it.
It seems to be missing on my end.
Let's see. Mohammed Muigai LLP versus Daniel Orenge and Company Advocates.
Okay, thank you. It's okay. Thank you. Thank you.
Who has his hand up? Because I can't see it very well. Or if there are no questions, I could I could answer the question by that have just been asked on perpetual injunctions.
I have a question.
If
Please go on.
My hand is up, and I have a question. I wanted to ask about what is the rationale or differences between attorney-client privilege and the doctrine of confidentiality. Thank you.
Thank you for that. Thank you. And confidentiality, my colleague who's doing ethics, that will answer that. Then go to Muturi. Muturi, I can see your hand is up. Then Ngugi Stephen.
Yes, thank you, Mr. Soronka. I'm the one who had asked a question on the profession undertaking, and I appreciate the response from the previous speakers. And I wanted to add something so briefly, because I also did my own research, which I find I agree with what the previous speakers have said. And I realized that a profession undertaking is binding even if it is to do something outside the advocate's control. Like, for example, in the case scenario, the bank went under receivership, which is something that was completely under the advocate's control. But that one cannot be used as a defense. As long as he did issue a profession undertaking voluntarily, he has to meet the terms of the undertaking. And even if, for example, the client, for example, the advocate was acting for the purchaser and the client fails to remit the funds, he is still obligated to meet the terms of that profession undertaking. Thank you.
Thank you for that. Thank you so much for that. Now we go to Ngugi Stephen, then Wangulu, Lorraine, and then Anami, then Grace.
Thank you. I'm the person actually asked about the rationale or differences between attorney-client privilege and confidentiality.
Oh, that's fine. That's fine. That's fine. Melanie. Melanie, please go on.
Good evening.
Good evening to you.
I wanted to ask, you mentioned two cases, Jella versus Castman Brown, and which other one?
Rao versus First American Bank.
Rao versus
First American Bank.
Okay,
First
thank
American
you.
Bank. Very good.
Okay, thank you.
Okay. Grace, go on. Then Zedekia, then now we close the chapter, we start oral mockups. We answer the questions, then we begin the oral mockups. Grace, go on.
Yeah, good evening. Mine is a probate question which I'd actually posed to you and you said you'd revert. So at what point do you file an objection to grant of letters of administration?
Nice. Thank you for that. Thank you for that. Okay, then we have Zedekia.
Mine maybe is to go back again to Maya, where she talked about we know theory, a lot of theory for purpose or examinations, especially about injunctions, executions, and what have you. I wanted maybe to know from whether they usually ask about to support your response to case laws, decided cases. That's what I wanted to know.
Thank you for that. Sumaya will handle that. Thank you for that. Thank you for that. So maybe I'll answer the first question on perpetual injunctions. So perpetual injunctions are just, in another term, they are permanent injunctions. When are these issued? They are issued after the suit has been given, after the suit has been heard and determined, sorry. So a perpetual injunction is just a permanent injunction. It's given after the suit has been heard. Okay. These others are temporary injunctions. What we're talking about, like don't evict her for this, don't evict her for this. Then after the case has been heard and determined, and the court finds in favor of Kyoko's client that indeed Kyoko's client should not be evicted, what will the court grant? They will grant a permanent injunction restraining them from ever evicting Kyoko's client. Is that clear on that basis? Is that clear?
Yeah, clear, sir.
Okay.
Thanks so much.
No problem. So it's temporary. It's temporary. After the suit has been determined and heard, it becomes permanent. Now we go to Lavin's. By the way, you need to answer these. One of my weakest areas is ethics and probate, but I can attempt. Any of you guys who would like to assist on that? They asked, what is the difference between attorney-client privilege and confidentiality? And then the probate question was on when do you file objections? Objections. Who's in? Is Kinesumaya in?
I can answer the question on attorney-client privilege vis-a-vis confidentiality. So, first of all, inakwanga it's usually a very there's a thin line between this. So you're saying there's a thin line between these two because ideally they're the same thing. The only difference is that attorney-client privilege is the privilege that applies to clients by virtue of having an advocate. Sawa. And this privilege is usually solidified when attorney-client relationship is formed, right? And there are many ways it's formed, as you will learn later on in ethics. It can be formed either by a retainer. There are different ways where attorney-client privilege arises, right? So by virtue of being a lawyer, once you've taken in a client, it can be a client you've taken in using a contract. It can be a client you've taken in by giving them legal advice, etc. Once you've given them that, attorney-client privilege dictates that whatever communication or confessions or anything that the client gives you or tells you is privileged, and you cannot disclose this information to anyone. So of course there are exceptions, and I think under the Evidence Act, I think section 134 or 140 something, please someone can counter check that, but in the Evidence Act, and those exceptions apply to.
It's 134.
134. Oh, okay. Thank you. So, but it's that. So, and those are the times where an advocate is required or mandated by law to break that privilege, and it includes when the client it continues to do some fraudulent activities or is involved in some fraudulent activities. There's also a new one which was recently introduced. It's trying to force advocates to tell when their clients are doing money laundering or countering financial or safety countering how do you put it, anti-money laundering or counter-terrorism financing. So that's also something which is upcoming and can be something that can be tested in ethics exams, right? So understanding privilege is that relationship. Sawa. Confidentiality, on the other hand, is now that blanket aspect that let me mute. Okay. Sawa. So yes. So now this is how I differentiate them, right? Confidentiality is something that exists generally between people. Sawa, it's not something which is mandated upon advocates. So for example, me and Brian can have a conversation which is confidential, right? It's just a general blanket of confidentiality. And as advocates, confidentiality applies in the sense that your client can come and tell you something which is not really advocate or it's not said in the advocate client area, but it's something which you as an advocate need to keep confidential and you don't go telling people. But now privilege is that confidential aspect that has now been codified into law. Sawa, that the law recognizes, number one, and the law gives exemptions to. So that's how I personally look at both of them. Sawa, confidentiality need not to be something that is between an advocate and a client, or need not to be something that forms part of client attorney privilege, right? A client can come and tell you that maybe it's a client who you're representing on a criminal matter, but they can come and tell you something unrelated on something else. Maybe they're having a fight with their cousin or something like that. So as an advocate, confidentiality entails that you don't go and tell other people or other lawyers about that issue, right? But that, remember, that issue is not really in the ambit of advocate-client relationship. But then everything else that is codified, that is in the law, in the Evidence Act, that has exemptions in other acts, are now advocate-client communication. Hope that makes sense.
Thanks, Sue. I think what I'd like to add is on Section 134 of the Evidence Act, still trying to expound on the confidentiality between an advocate and the client. So when you look at Section 134 of the Evidence Act, it basically provides that no advocate at any given time, shall be permitted unless, that's the catch, unless, with the client's express consent, to disclose the three things. One, to state the content, and or the condition of any document with which he has become acquainted in the course and for the purpose of his professional employment. One. Two, to disclose any advice given by him to his client in the course of and for the purpose of such employment. And then lastly, communication made to him in the course of and for the purpose of his employment as an advocate by or on behalf of his client. So if we try to link this with the privilege, you'd see that this particular privilege under Section 134 of the Evidence Act, does not extend to communication, that's made in furtherance of any illegality and to any fact observed by an advocate in the course of his employment, which indicates that a crime or fraud has been committed since the commencement of this particular employment. So the privilege itself, applies to interpreters, clerks as well, or the employees of the advocate or the firm. This is under Section 135 again of the Evidence Act. So Section 137 itself, again of the Evidence Act, provides that no one shall be compelled to disclose to the court any confidential communication which has taken place between himself and his advocate, unless he offers himself as a witness, in which case he may be compelled to disclose any such communication as may appear to the court necessary to be known in order to explain any evidence which has been given. So Maya was talking about the money laundering. I think advocates at the moment are protected under, I think, Anti-Money Laundering Act. There's such an act. Yeah, so you'd find that the crimes, of money laundering,
The Procamla. Yeah.
Sorry?
It's called the Procamla, Proceeds of Crime and Anti-Money Laundering Act.
Yeah. That act, please go through that particular act. It will help you understand and distinguish between confidentiality and privilege. But that said and done, the two would emanate from the fiduciary nature of the advocate-client relationship. So the two are distinctly independent of each other, and at the same time, they're interdependent. So yeah, over to you, Solonka.
Okay.
I wanted to add something about that. You talked about Section 137 and giving about revealing documents and at all. And when I'm looking at Section 58 of the Tax Procedures Act, it actually gives officials the mandate to search, take any document that they deem fit when it comes to this kind of when they actually investigating tax matters, anti-money laundering. Don't you feel like, or is there a contradicting, is the law contradicting itself, whereby Section 137 is giving us that you're not supposed to do this, but then Section 58 of the TPA is giving officials the power and the mandate to actually do that with your whatever, whether you like it or not, and so, you can use it to actually obtain any document you want. Kindly comment on that.
Solonka, I don't know if I got him clearly. It was in a noisy place. I don't know. He asked about something to do that. Is it the tax Procedures Act.
Yeah, Tax Procedures Act.
Sue.
Section 58 precisely.
Okay, Stephen. Sue. Is Sue here?
Yes, Patrick.
Yes.
You could kindly highlight on that, because there's some part I didn't get to hear. I don't know, because it was breaking or something.
Yeah,
But
please repeat the question. Pia Mr. Jello, your question vizuri.
Maybe to try and answer him. He's asked about the Tax Procedures Act. The Tax Procedures Act, with regards to, it may require advocates to maybe release some records and something of the sort. And something of the sort. I think that's in line with the question. Yeah.
How is that a conflict with ethics?
Power to inspect goods, not conflict in ethics. He was explaining more and trying to show that there is some sort of conflict between that section 58 of the TPA and the Evidence Act, which provides for the advocate, the issue that advocates cannot be compelled to release certain documentation pertaining clients, or to maybe give information pertaining clients. So if you look at
okay. But I think there's a slight difference between when it comes to that, because when it comes to the Tax Procedure Act, the documents that you're mandated to release when either it's needed by the tribunal or KRA or anyone are documents that are public documents generally, right? So those are documents that entail your tax returns, that entail maybe your receipts, VAT receipts, stuff like that. But when you look at what the Evidence Act from Section 134 to 137 is trying to say is that what is privileged, documents that are general public documents cannot be privileged. They're not protected by privilege at all. You can't say that me and my advocate at our plaint or something, or our tax returns those are not privileged informations. You not get privileged information is the communication that you will have when a client wako or your client or a client or someone else have had in relation to a certain subject. So if that makes sense. So privilege does not extend to public documents or any documentation, that has to do with a government or any public sort of setting.
Yeah,
okay. I understand that, and actually understand that, and I'm not actually talking about the public documents. I'm talking about the new wave of how tax fraud and evasion is actually being dealt with. Tax officers have been given the mandate to actually come to your premises without warrants, to search, make copies for any relevant document that they deem fit to actually help KRA to recover those taxes.
Correct. So, sorry, I now understand the question. So what generally happens is that once the documents have been taken by KRA, I think that thing is being challenged in court, if I'm not wrong. But once the documents have been taken by KRA, anything that entails advocate-client information cannot be used in court. And that goes to Article 50 of the Constitution that talks about the right, not to have not to have illegally obtained evidence used against you. You see, so illegally obtained evidence entails information that is as a result of advocate-client information. Does that make sense? So KRA can come all they want. They can take all your documents and everything. But if they do end up using any evidence that entails advocate-client relationship, and in that are able to build a case, then if you can use the evidence rule and talk about, how Kenya approaches illegally of evidence and it's against the Constitution, then of course your client can walk home free. I hope that makes sense.
Yeah, and then maybe on that also, on the issue of illegally obtained evidence, you need to note
it's not
that
illegally obtained evidence. They actually use the law to actually obtain that evidence. It's actually written down that you can actually make copies and do.
Yeah, but it becomes illegal once it's advocate-client information. Does that, as in, okay, I don't know, but maybe we can side chat. Maybe talk about this. Sawa.
Yeah, I actually understand it because I've seen cases in the tax tribunal whereby if you understand, KRA has an intelligence.
Yeah, they do.
So, so that intelligence wing actually obtains this kind of information and actually bring it to the legal side of KRA to actually bring suits to people. And most of the time, these suits, KRA actually wins most of them, to be honest. So for me, I wanted to actually understand how we've actually let it to be so cavalier of the law that we can actually allow these things to happen. Yeah? And we actually know the way they're actually happening. I don't know.
Yeah. Okay, please go. Please, Stephen, share the case to any of the groups that you're in. We can have a look, and then we can look at it next week. I think we need to go into the oral prep right now. So just share the link. We'll read a case that has to do with the legal obtained evidence, and we see how the tribunal or the High Court ruled on it, and then we can discuss it next week.
Yeah, and then you also need to note something. Maybe now before Alex jumps into it, you also need to note something about. So even about illegally obtained evidence per se, if you read the Constitution and what it provides for, is evidence that is obtained in a manner that violates any right of fundamental freedom. Yeah, and so when you're reading a particular statute or a particular provision of the law, you need to read it as a whole. Yeah, so you need to check out. There is the issue of Section 58 of the Tax Procedures Act. There's the issue of the Evidence Act, Section 134. Yeah, so the question will be, and this is something that will happen practically if it goes to court, is the other advocate, rising up and making an objection. So, okay, you already obtained this thing, but I will object on its admissibility. I will say that this thing is not admissible because it's based on advocate-client privilege. And if you read and have a look at the wording of Article 50 of the Constitution on the issue of evidence that has been obtained in a manner that violates any right of fundamental freedom, in summary, illegally obtained evidence in Kenya is admissible. It is admissible, but it is upon the other party to show that if this thing, this evidence, if admitted, will prejudice my right to a fair trial and it will be detrimental to the administration of justice. So it is admissible. So what will happen in in Ngugi's case will be this KRA comes, searches your house, does everything and all that, obtains some documents that is confidential according to attorney-client privilege or confidentiality in the Section 134. The advocate will just rise and maybe make an objection and say, this thing will not be admissible because of so and so and so. Recourse will be on Article 50 of the Constitution and say, if this thing is admitted, it will be against the administration of justice and will infringe on my fundamental rights and freedom, and then proceed to give evidence and show how it does so. If it does so, the court will now rule on that basis and say, okay, we will not admit this thing because of this and this that has been adduced on there. So it's not casting stone that KRA can just come into your house, take your documents, and do all that, and then the same evidence will be admissible to you. You have to read all these sections of the law together wholeheartedly. And to clarify on the issue of illegally obtained evidence, it is admissible. It is admissible unless it will render the trial unfair or it will be detrimental to the administration of justice. Alex, you could maybe contribute on that, and then now we go on and begin the oral mock-ups. And actually, after you finish, guys, you can start raising your hands, then now the questions will start coming. So Alex and Sumaya will take the first batch of questions, and then now we'll proceed from there.
Okay, mine was I was to answer the previous question. I think the question was the difference between confidentiality and advocate-client privilege. That was the question. So this question is asked by Maloa. I know he's one who asked you this question. The difference is quite straightforward. Confidentiality belongs to the client. If you are an advocate and a client walks into your office and they tell you anything about whatever they have done, you must keep it confidential. So it's for the client, it's not for the advocate. The client is entitled to confidentiality. So it belongs to the client. Whatever they tell you, you should not tell anyone. That's what is called client confidentiality. If someone tells you they murdered somebody or they did whatever they did, it's for the client. You can only tell anybody if the client allows you, or if the circumstances allow you to say it, or if you have a dispute with the client. That's only when you can disclose that information, but it belongs to the client, not to the advocate. But then, advocate-client privilege belongs to the advocate, in the sense that if the client gives you any information, no person can force you to give out that information. It is privileged. That the government cannot come and tell you, you know what, give us this information about this person that you have. You'll just remove Article Section 134 of the Evidence Act and you say, there's advocate-client privilege. I cannot give you information which I have belonging to my client. That's the difference. If you are asked, and he will ask you during orals. If he asks you during orals, that is the answer. They are different. They're not the same. The confidentiality belongs to the client. Advocate-client privilege belongs to the advocate pursuant to Article to Section 134 of the Evidence Act. Thanks. I hope you have understood.
Yeah, thank you for that. Arunga actually has his hand up, so
Yeah.
you guys start asking him questions. Then now he'll ask his after.
I just wanted to add something quickly, and it's contrary to what Alex has just said. There is the Professor Tom Ojienda case, especially I'm relying on the obiter in the one for the High Court, because that case went to the Court of Appeal, but also the Court of Appeal made a determination on the same. The High Court said that in the advocate-client privilege, that the privilege belongs to the client, and the advocate only enjoys he only enjoys the privilege of non-disclosure. The advocate only enjoys the privilege of non-disclosure in that relationship, and the client is the one who has the privilege that is trying to be protected by the law under Section 134 of the Evidence Act. Yeah.
Okay, I get you what you are saying, but you see, look at it this way. Confidentiality is not codified. It's just, but it's another difference. Confidentiality is a common law doctrine. Sorry, yes, confidentiality is a common law doctrine, but advocate-client privilege is a statutory creation. It's created under the not Advocate Act, Evidence Act. So that's the first difference. The second difference, and with response to what you have said, yes, in as much as advocate-client privilege seeks to protect the client, it is in real sense it seeks to protect the advocate himself, so that the advocate cannot be compelled to disclose this information. And it's a very thin line, because under what other legal provision would an advocate refuse to give out information? There's none. But if they are required by any person to, or they are coerced or they are forced to give out this information, they can only go back to Section 134. And this is, maybe you might, but this is how Malloy reasons. I know that is his question, and that is the answer that he gave us. That when it comes to advocate-client privilege, Section 134, advocates, they're protected. Confidentiality, it belongs to the client. It can only be waived if the client agrees to waive it. It's a thin line, and there's a difference which most people can confuse. You see now, the you are saying that the advocate-client privilege protects the client. Of course, it protects the client. Of course, it does. If it is protecting the advocate, it is also protecting the client. Because if the advocate discloses this information, it does not seek to be used against the advocate. The person requesting for this information or coercing the advocate to give it this information, it wants this information to use it against the client. So either way, it protects the client, but as a lawyer, it seeks to protect the lawyer. It's a thin line. I don't know if I'm clear enough, but I hope you just get it. And if you find it during orals, or if you appear before my lawyer, just make sure you get it right. Thanks.
Okay, let me just get the obiter, then maybe
Okay, now as you get it, Arunga, we need to start the oral mock-ups. Then we begin. So guys, who wants to begin?
So
Actually,
long
yes?
my question has not been addressed yet.
What was it? Please repeat.
It was at what point do you file an objection to grant of
Oh,
letters of
sorry. At what point do you file? Okay, let me try, and then the other guys will jump in on that issue. So objections in probate, you need to check section 68 and section 69 of the Law of Succession Act. And there's a very good by Justice Angao that provides for all these things, objections, protests, and so etc. So after you file your those applications for grants, you have 30 days. There will be a 30 days advertisement that will be made. Yeah, objections are made within those 30 days. That's the short answer. So you file the application for grant of letters of administration. After you file it, there's a gazettement that happens. So there's 30 days there's a 30 days window that is usually given. Now, during those 30 days is when you can bring an objection. This is yeah, go on.
Let me just continue from where you left quickly before, like, in 2 minutes, and then we begin our orals, please. Yeah. So the person who asked this particular question, I don't know your name, but I hope you are listening. So objection proceedings, you will usually turn on the issue of entitlement to and the suitability of the petitioner to a grant of representation, and the heirs or beneficiaries or dependents, usually commence them. So in intestacy, the persons who should file this particular objection proceedings are those set out in section 35, 35, 36, 38, 39, 40, 41, and 66 of the Law of Succession Act. And then intestacy, I've talked about intestacy, so this one is testacy. So here, the objectors should be those challenging the validity of the will, okay? So the qualification for bringing these proceedings is not dependency, but beneficial interest or heirship. And you have to know that the only issue for determination in these proceedings should be whether or not the grant should be made to the petitioner. So a court, which finds basically that the will is valid, should not venture to determine whether the objectors are dependents. It should make a grant to the executors named in this particular will, or is none a name to the persons entitled to the grant under section 63, 64, and 65. And lastly, confirmation and revocation proceedings, are also specific proceedings which are designed basically to just, give a voice to the specific issues and concerns. They are not suitable for addressing the dependency matters. So that's how intestacy and testacy differ in terms of objection proceedings. So if you look at section 35, 35, 36, 38, 39, 40, 41, 66, and then 63, 64, and 65, I think you'll be home and dry. So with that, I'd request, implore, and entreat that we embark on orals so that we can kindly be within our time frame. So I know you may have more questions, but please, you can always reach out to us privately so that you could address your concerns. But for the purposes of time, kindly allow us to proceed. So Solonka, you can, I think Alex and Sue want to begin.
Yeah, they can take Otieno. I'm seeing Otieno Belinda. Otieno, you can begin with Otieno Belinda.
Sorry, Solonka,
Yes?
Okay, thank you. Because it has been requested that we give time for the oral session to begin, I just wanted to ask a question in relation to what you are answering. And it's a quick one, on whether someone can bring an objection when confirmation is almost being issued out and the 30 days have elapsed. Is it possible?
Alex, go on. Alex can take that. He was actually answering it.
Okay. In response to that question, a person who wishes to to make an objection must do so before the lapse of the 30 days. That's why there's a timeline. You cannot after the 30 days, I think you can apply for, is it a revocation of the grant? Yes, a revocation. You usually don't apply for an objection after 30 days. So you have to do it within 30 days. And then the question which she asked was grounds for which a person can make an objection. And there are usually, I think, 3 grounds.
Oh, sorry, Alex, 1 minute. After the 30 days elapses, after the gazettement, is when you apply for a protest.
Exactly, yes.
Yes.
But
So the
not
document, Belinda, the document is called a protest. Sawa. So you apply for the protest, and the protest can be done any time until the final confirmation of the grant. Once the final confirmation of the grant has been done, now you apply for revocation. So number 1, you apply for objection. Then protest is a period between the temporary confirmation to the, a final confirmation. After final confirmation, the sign a revocation. That's the timelines.
Belinda, Belinda, please look at the case of, in the matter of the estate of James Karanja. I think you'd be able to understand more, and the rest of you. So in the matter of the estate of James Karanja, just look at that case and other supporting cases. So Mr. Solonka, please. Time is of essence. Yeah, so kindly take it away.
Oh, Dido, I'm seeing Dido is here. Seeing several guys. So who'd like to volunteer to take up the first batch of questions? Remember, the more you practice, the more you tune your brain into. Oh, I can see Alex's hand is up. Yeah, the more you tune your brain into preparing for the orals. Seeing Dido. Dido, are you in? Alex can go on as guys if their hands up to volunteer.
So who has volunteered? Who is the first volunteer?
Let me try and access their name. I'm seeing Robert Kelvin. Yeah, Robert gone. I'm seeing Robert Kelvin. Yeah, Kelvin, Robert. So Sumaya and Alex can take the first batch, then we can take the other.
Okay, Robert.
Yes, Alex. Good evening.
Good evening, Robert. Okay, so if you can start with the questions, I just want to ask a mix-up of different units, then you can try and answer, and then we can see how it goes. So my first question is, person X made a will and then was murdered and later died. What is the position of the will?
Kindly come again, Alex.
Okay, person X made a will and then they got married and they died. What is the position of that will?
Okay, thank you so much, Alex. Thank you, Alex. First of all, that question goes into the validity of a will. And there are several factors which can make a will invalid. And one of those factors which can make a will invalid is a subsequent marriage after the will was made. This is because the rationale is because a subsequent marriage brings in new parties into the picture who are not part of the consideration when the first will was being made. So as it stands, this will be invalid for reason of a subsequent marriage.
Okay, a follow-up question. Is it absolute that that will be invalid?
Thank you once again. I think, and as time guided, but I think it is not absolute for the reason that it will depend. It will depend on the. It will depend on the second marriage, on the quality of the second marriage. If it is a valid marriage, where someone can be able to obtain a marriage certificate, yes, in that sense, it will be absolute. However, if it is a void marriage, a subsequent void marriage, then in that case, it will not be absolute.
Okay, thank you. The second question is what was the decision in the landmark case of Anarita Kareminjal versus Republic?
Thank you, Alex, for that question. I think that question will form my first assignment after this discussion.
Okay. So the third question, what do you understand by a derivative action?
Thank you, Alex, for that question. What I understand by a derivative action is that a derivative action, these are remedies by minority shareholders. This is one of the recourse in which minority shareholders can bring out their grievances against the majority shareholders in a company.
Okay,
in a derivative action, the member sues in the name of the company, and the member pursues a prayer on behalf of the member himself, not on behalf of the company.
Lastly, what is the principle in the case of Force versus Haboto, 1844? Force versus Haboto.
Thank you, Alex, for that question. The rule in Force versus Haboto, this rule prevents shareholders from suing for a loss in the value of their shares brought about a wrong done to the corporation. I could say that it is a rule which is a consequence of the separate legal personality of the corporation.
Okay, thanks. So that's the end of my question. Maybe do I respond or do I wait for Sumaya to ask her questions before I can give my feedback?
Maybe you can wait for Sumaya, then now you guys can equally now give your feedbacks.
Okay.
I don't know. I feel like Solonka, sorry, I think we should do our feedback first, because that way someone improves on the next round. So I think just Alex, go ahead with the feedback.
Sorry, Sue. You see, each round has two people asking.
All right, and then we give feedback after we are done.
Then I give feedback after, because orals, it's an oral mock-up, and when you go into that room, you ask questions by two lecturers.
Yeah, that's true.
Oh, okay.
Sawa. Okay. Hi, Robert. How are you?
Fine, thank you.
Can you tell me something about the suit you're wearing today?
Today is a Saturday. I have been in unofficial clothes. However, talking about suits, we have the LSK Code of Conduct, which talks about the dress code for advocates. And in any case I was to appear with you before you, I will be accordingly dressed to that code of conduct. Thank you.
Okay. Thank you for that. So can you tell me 2 or 3 different ethical code of conduct or standards that advocates are regulated by?
Thank you so much. Thank you so much for that, Sue. One of the ethical conducts in which regulate advocates, one of them is honesty and integrity. in this, an advocate should act in the best interest of the court. An advocate has a duty to the court. He should not mislead the court for this reason.
Okay, thank you, Robert. That is insightful. However, I'm looking for specific names of certain rules that exist. For example, advocates accounting rules. Do you know others?
Well, so let's say I am not so knowledgeable about that. However, I have indicated it as a reading material.
Okay, that's fine. Okay, can you give us? Maybe I can go to another unit. Can you tell us the difference between a judicial review and a review?
Thank you so much. I will give it an attempt. I am not so sure, but I think the difference will be. Let me attempt to the best of my knowledge. I know one of the differences that one of the reviews, I'm not sure it is the judicial review or it is the review. One of them pertains looking into decisions by administrative bodies, and the other one is about looking into a judicial decision.
Okay, thank you so much. Just the last question, Robert. Why did you choose law as a career?
I chose law as a career because I have a dream, I have a passion, I have goals, and to achieve these, I need to be knowledgeable in the area of law. I need to be equipped with skills so that I can be able to deliver and give back to my society.
Okay, thank you so much. It was a pleasure asking you questions. That's the end of today's session.
Yeah, you guys can give feedback now. Me personally, I think he did very well. He didn't pass any question. He was very confident.
Yeah.
Give him an
Honestly,
18 out of 20.
Yeah, I'm actually, giving clap emojis. So nice attempt, Robert. So I have a few things I'd like to give as feedback. First of all, let's start with the positive things because those ones are meant to motivate you. I love your confidence. Very good on that. Number 2, I like your intonation. Your speed is very good. It's something someone can listen to and comprehend easily. I like that. So I need to improve on a few things. And when I was asking these questions, I tried to ask both sort of like quote unquote general questions and also content unit specific questions. So first of all, let's start with the last question. When you asked something on why did you do law? That question is a very simple question. You might think of it as, oh my God, you leave the order design like, oh my God, ask an easy question. I'm gonna, get a 19 or whatever. But that question is supposed to test your advocacy skills. Sawa, it's supposed to test your child advocacy skills. So just don't say I have a dream. Give a story. Like tell these people, when I was young, I don't know, danganya. This is up and chocha yako yote inatakikananga. Give someone a story. Remember, again, it's an easy question. So if you ask in your first or couple of questions, it's up to you to make sure you drag and milk this question as much as you can. So give a story. Say how when you're young, you're brought up in a certain village, and in that village you're able to see, maybe children who are uneducated and don't have rights, or things that essential people will care about, like all the examiner kwa hiyo room anajua. We both know we're in this career for the money, no doubt about it. But then it's supposed to give such a emotional story that someone actually sees your child advocacy skills. So talk about how, certain someone, maybe grew up, talk about police brutality, talk about women's rights, talk about domestic abuse, give a very touching story. It can be your family, it can be your neighbor, it can be someone, and then say, that because of that, I realized the way I can help these people is by, becoming a lawyer. And so I've taken up law to do that. And, once I finish my Kenya School of Law, I aim to do ABCD. So such questions test your advocacy skill. They try to test your comprehension, your flow, and your story skills. So start from the beginning, talk about your background, talk about why you did that, what inspired you to do that, and what you're planning to do in the future. Number 2, the first question I asked you on your suit was a very intentional question to get you to talk about the dress code. And I loved how you were able to catch that. That's a very good attempt. Congratulations. However, once you're given such a question and you've already identified, ushajua, I'm supposed to talk about the dress code, then tell me more about the dress code, right? There are things you know about the dress code. You know that you should have mute colors, you know that it should be, you know, extremely flamboyant, you know that male advocates should wear closed shoes, they should wear certain types of colors, you know that female advocates should have braids that are mute colors, you know that they should wear certain type, you know. So go into the dress code. It's not enough for me to know that you know, referring to the dress code, you need to actually, you know, tell me something that you know about it. So, yes. And then for the other two questions, my general feedback is for when you're asked, the first thing, when you're asked a question on differentiate between A and B, first of all, the rule of thumb is always start by defining. Sawa. I liked how you're honest and you said that you know you don't have a good idea of that. That's very good. But start by defining. So start by saying a review is when dash 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 happens. A judicial review, you know, is when a certain or court looks into a decision made by an administrative body or a quasi-judicial body. Start by defining. Once you start by defining, you might, as the beginning, by the time you're being asked a question, you might not know the difference. But when you start defining it, then the difference comes automatically by the definition. So that's one tip. General observation, I think there's another question I asked you, I can't remember it, but general observation, very good on the confidence, all that is A1. Please try to take, like when you ask the question, try to take a minute to internalize the question. Don't reply all your questions with thank you for that question. You can vary. I think there's a document I've sent to all the groups right now. It could like a sample of things I wrote there on how you can vary. So the first question you can say, thank you for the question. The next one you can say, that's a very interesting question. The other one you can say, your question raises insightful, you know, thought. Something, vary them. Sawa, usikueti. Let the panel know that it's a conversation, it's flowing, it's not something you've rehearsed. Sawa, do that, as in make sure you vary that. And then one thing I'd like to also add is that that's from Alex's, you know, questioning. I noticed that when he asked you questions on case law, you got a bit thrown off. So maybe you can do a bit of practice on that. But I think other than that, you're good. So avoid the mechanical answering of questions. Take a minute to digest the question, or like a second. Then always start by defining. Trust me, if you always start by defining, like the question on the will, the first thing you should have done is said, a will is a testamentary, you know, instrument that is sworn by a testator, you know, that shows how they want to divide their property, something like that, how you can define a will. So rule of thumb, start by defining things. It will help you organize your thoughts. It will help you, by the time you're defining that thing, you're already having a structure of how you want to answer your question, right? So yeah, that's what I'll say. But very good attempt, Robert. I think that was really amazing.
Thank you so much, Sumaya. The question which you left out, which you had asked me, was about ethical conduct for advocates. I don't know whether you'd like to go to the same.
Yeah. So this is okay. So first of all, there's a general one. Just maybe an answer to this is have an idea about this code of conduct. They're very important. Number one, kuna the general one they call the SOPEC. You know that, right? All of you guys know SOPEC. So there's SOPEC. But then there are specific rules that also govern advocates. So kuna the marketing advertisement rules, kuna the accounting rules, kuna the judicial conduct, you know, code of conduct. So these are also rules to code of conduct. So the question that the one you're answering the SOPEC. I think that was SOPEC 12 or an 11 you're using. So just also familiarize yourself with other codes of conduct, because everyone probably by the time mnafanya orals, everyone will know SOPEC. You know the ones that are there, but try to know, are there like other codes of conduct that also govern advocates, and then try to know that those ones are. So just have an idea. Just know that advocates rules now govern how advocate accounting rules governs how advocates, conduct themselves when it comes to client money and in relation to their finances. So just have I'd say just have a general idea what these rules are. You may not have read them all exhaustively, but you know what they talk about. Yeah.
I really appreciate. Thank you.
Okay, I can give my feedback. I think Sumaya has noted most of the things which I would have said. I think your confidence is very good. I think your speed also is spot on. You should not be too fast. You should not be too slow. You should just be hapo katikati. No, don't lose your audience who are the panelists. I think you have tried to answer questions. Like, if you have another thing that I've really liked, if you have an idea about a question, just try to answer it. Don't pass. I think you have tried to answer like most of the questions. Other than that, I think there are some questions if you are asked and you don't know, in my opinion, just don't answer them because they might you might answer them and sound very stupid. That's my personal opinion. You know, people insist that try and answer all questions. Yes, try and answer all questions. But there are those questions which you really have no clue, and you might give an answer which sounds like it's not. There's none which have given such an answer, but I'm just saying, if you really don't know the personal law was asked a question, the lecturer read a case law. I think I told you last time. I told you guys last time. The lecturer read a case law from their notes, and they asked me what are the facts of the case law, not even the rich. What are the facts? I just said, hey, that one pass because you don't want to sound like a liar or just a person. Of course, most people appear before the panel and try to beat around the bush. Sometimes you don't want to appear that way. Other than that, to the answers to the questions, the first question I asked you was, a person has got married, a person has written a will and then they've got married and then they die. What is the position of the will? And you are right. The position of the will is that the will become invalid because the rationale, as you said correctly, is that you did not anticipate people who are to come into your life after you wrote the will. That is the assumption. But is that position valid? Is that position absolute? The answer is no. When you read, I think it's section 19 of the LSA, section 18 from 19, it says if you make a will with the intention to marry after making that will, even if you die, the will will not be invalid just because you made it before you married. Let me repeat. Section 19 says, yes, the general rule is that if you die, if you make a will then marry, the will be invalid. However, if you made that will anticipating to marry, the will not be invalid. So you have to, and this is for both orals and the exam. It might come in question 1 in your by exam. Somebody makes a will anticipating to marry, is the will valid? The will be valid. That is, and maybe at this point I can introduce one of my friends used to say, the oral exams is for those students who read widely, but the by exam is for those people who read deeply. I think I told you this guys last time. So even if you are reading for the oral exam, don't just read widely. Read deeply. Read between the sentences. Maybe you can. Some lecturer will just go and look at something and say, oh, by the way, I can ask this during orals. And then there are those questions which you answer. Every other person has been asked before you got it wrong, and just because you have got it right, you get a 19 or 18. Just because you get that one question right. So just try to maximize on it. My second question was Anarita Kariminjaro. This case we talked about it last week. Anarita Kariminjaro was a criminal case about constitutional law. The lawyer appearing that case was Amino, Dr. Amino. I think you guys know him. And he just drafted a petition, but did not claiming that the constitutional rights of Anarita Kariminjaro had been. No, he defended without claim. It was a criminal case in which Anarita Kariminjaro had been sued, but then Hamino filed a petition against that criminal case, claiming that the constitutional rights of Anarita Kariminjaro had been infringed. But then he failed to indicate the actual provisions of the Constitution which he claimed were violated. So the court said that a petition claiming that there have been infringement or violation of constitutional provision must be precise as to which provisions of the Constitution have been violated or infringed or threatened. So you must say, yes, the actions of this person violated Article 22, 23, 31, whatever. That's the rationale of the case. And it's, if you read almost all the constitutional petitions in Kenya, they mention that case, Analita Kariminjero. The respondents will always bring it up. So it's a case you should know. The third question I asked you was, what was a derivative action? And you really tried, you got it right, but you did not capture it very well. But that's why I said that you tried. If you have an idea, just try. Don't say at the past because maybe you cannot remember or something. A derivative action basically is a claim brought by a shareholder on behalf of the company. If I own shares in Safaricom, for example, and the directors of Safaricom have refused to bring a case in favor of Safaricom because of their personal interests or whatever, as a shareholder, I can go to court and sue on behalf of Safaricom because I'm a shareholder. That is a derivative action. A member of a company suing on behalf of the company in the name of the company. But you cannot do that. Usually, it's not allowed. A derivative action is an exception. A company is a legal person. It can sue or can be sued in its own name. And that's why I asked you the second question, the principles in force versus haboto. The principle of force versus haboto is one of those landmark cases which you should know. So, and I think that's another area, as Sumaya has noted, you should look. These landmark cases, Anarita Kareminjeru, Salomon versus Salomon, Force versus Haboto, Giela versus Castman Brown, owners of Motoveso. This other case last week, there's another case about, I don't know, I don't remember well. You should know those cases. So you should have an idea what was the ratio. Because the ratio versus Haboto was that a company can sue or it can be sued in its own name. So that's the principle. So what happened in the case of Force versus Haboto is that shareholder just went and sued in the name of the company. There were some facts I don't remember well, but then the company defended itself and said, the defendant said, no, this person cannot sue on behalf of the company. He has no right. The company is a legal person. It can sue or it can be sued in its own name. And the court agreed with the person. It's an 1844 case. You can just Google Force versus Haboto. You'll find that is the general rule. And there are exceptions to the general rule. One of the exceptions is the principle in it's a derivative action. When you read section 238 of the Companies Act, you will find a derivative action. That is one of the exceptions. The second exception is you can bring up a winding up petition. As a shareholder, you can. That's another exception to the case of Force versus Haboto. A shareholder can bring when you look, I think at section 424 of the Companies Act, it talks about members of the company bringing a suit to wind up the company. And the other exception is unfair prejudice petition. When you look at section 780 of the Companies Act, it talks about unfair prejudice petitions. Those are things you should know. I really would have admired how you have gone about the questions, even if you are not aware about the answer, you did not know the actual answer, you tried in the questions which you had an idea. And the questions which you are not having a clear idea, you just opted outside. And I think I admire that. You are confident, you are articulate, you are fast, you are not too fast and you're not too slow, your speed was okay. And I think if you just polish in those areas which we have noted, I think it will be okay. Thanks.
Thank you so much, my brother Alex. I really appreciate. Maybe if I could, I will ask a question which I would like to seek a clarification.
Yes, please go on.
When you asked the issue about wills, in my mind it occurred that wills are provided for between section 8 and all the way to section 17 and 18. However, the issue about remarrying is in section 19. So for a moment or two, I really deliberated about giving you a specific section about the law. I know if you give the correct section of the law, that is an added advantage. But my question will be, what if you find yourself in a situation where you are actually a bit confused about the sections, because I was not really sure whether to give you a section, and I find that I missed it. And I didn't know whether I could tell you that wills are provided for between section 8 and section, let's say 18, and whether that would be proper.
Kevin.
Okay,
How
thanks.
are you? Alex, just a minute.
Okay.
Kevin, how are you?
Fine, thank you, my brother.
Awesome. So you don't have to give the section of the law if you are not sure, but you have to give the principle behind that particular provision of the law that you aren't sure about. So if you have the principle in hand, then just give it out and mention a section that is wrongly put, and that may even lead to you can never know what the panels are going through at that particular moment. Maybe some have issues at home or everything. So yeah, so one wrong thing may lead to sort of bad. So yeah, quote the principle that you know and forget about the section. It's better that way. Alex?
Yeah, I think maybe just before Alex takes the mic, I don't know, I feel like it depends. And again, this is why I say orals is all about careful phrasing of your words. And that's why I insist on starting by defining things, right? So if you say this, for example, you've been asked a question of intestacy, Sawa, we all know that intestacy is from generally section 32 up to 40 of the LSA. Sindio? So you're not sure. Maybe you've been asked a question on where there's a surviving spouse and no children, and you don't know how to go about that question. But you know the principle, and you're trying to get yourself bonus points. So you can start by saying intestacy, is a scenario where the deceased has died without leaving a valid will or testamentary instrument. It is generally covered from section 32 to 40 of the Law of Succession Act. In this question, the principle, is this and this. So you see, in that way, umeonesha panelists that yes, I have an understanding generally of intestacy, and I know what the sections are. Given the opportunity, I can be able to research them and discuss them further. However, I don't have that specific section in mind at the moment. And trust me, that's what saved me in my bar exams. There are things I was not bothering to read. But to come a company law, hey, that act is so big, you have no time to shake other. You can't shake all the sections, let's be honest. And sections, at the end of the day, and people will always tell you, especially when it comes to bar exam, people tell you all sections don't matter, so just make sure sections. And yes, it works for them. However, sometimes knowing certain divisions can be a plus. So there are basic things like insolvency, like bankruptcy, where the petitions are, draw to the area, journey from section this to this. Si lazima ujue everything. Like si lazima ujue every single section, but have a division. So what I did, like for the LSA, I had divided it in the sense that I know generally from section 5 to section, I think the one you mentioned 19 is when it comes to testacy. Section 30 is the exceptions to communal property. Section 31 is donatio, 32 to 40 is intestacy, 77 76 ni revocation. So have especially with this quote unquote, I'd say easier units, things like probate, things like ethics, you need to know those acts. That's what makes you sort of stands out, right? So for orals, you might not know, and even if you don't know that, as Patrick said, even if you don't know the exact section, talk about the principle. I agree with that. However, you can also mention the act as a blanket. You can say this certain principle is discussed in the Advocates Act, full stop. Then you talk about touting or you talk about marketing. Sawa. So don't stress yourself so much with sections. However, if you can find a blanket way to cite them, I think that would also really help. So, and then I was just about to say what you can do, because I noticed for the landmark cases, Anarita is a very important case, just as Alex said. It's one of the most important cases because it talks about being precise in what you ask the court and being precise in what you draft and being very precise in your drafting. So what you can do, maybe we can start, I don't know if you guys use Google Docs, but we can create a Google Docs link. I can make it public. We can write down all the landmark cases that you guys need to know before you enter exams. Probably no one will ask you in your orals, no one will ask you in your final exams, but having a list of them help. And Alex mentioned a couple: Force versus Habertol, Salmon versus Salmon, Anarita, Giella. Like, these are cases that you need to know, even like just to become a generally good lawyer. So maybe I can create a Google Docs link. You guys, enter, fill in whatever you think is landmark, and Dika under the unit, and then I think people can just have an idea and revise before the exam. Yeah.
Alex, do you have
Okay.
further comments?
Okay, I think what I could have said has been sufficiently addressed, other than what you have asked about section, with the particular section. So the section is section 19 of the LSA. Let me read it. It says, a will shall be revoked by marriage of the maker, but where a will expressed to be made in contemplation of marriage with a specified person, it shall not be revoked by the marriage so contemplated. So generally a marriage will revoke a will, but if it was made in contemplation of marriage, then it will not revoke. It will not revoke. And of course, you have to note contemplation of marriage with a specific person. Just for your information, read deeply and read broadly. And other than that, I think Sumaya and Lavins have addressed the issues of the other questions you had asked. Maybe this is my time to allow other people to ask questions, or Solonka and Lavins, except if someone has a question for me and Sumaya. Thanks.
Thank you, Alex. Thank you, Pareno, PLO, and Sumaya for that opportunity. I appreciate.
Now you'll do great. You've passed my panel. Thanks a lot, Kevin. Now we have.
Same, by the way, even in mine, you've passed.
Yeah, passed highly. Now, okay, I'm seeing 3 hands have been raised. Now, let's start with the ones who've not spoken. I'm seeing Mudhami Kavudha. So Mudhami, before you proceed to ask the questions, I'll ask you a few questions. We'll do this with the Lavins. Then you can proceed to ask your question. Are you agreeable to that? Mudhami Kavudha.
Hello, yes.
Okay, no problem. So I'll let my colleague Lavins begin. Then now he'll hand it over to me. And now to keep it short so that everyone will please keep it a bit short. So Lavins, you can begin, then I'll take it over.
Awesome. Thank you, Senior. So Mudhami, greetings to you. Be brief. And yes, all the best. So I'll begin. So you are a divorcee and you'd like to drop the name of your ex-husband. Which document will you instruct your advocate to draft? I'll repeat. You are a divorcee and you'd like to drop the name of your ex-husband. So which document will your advocate draft to effect that change? Hello, is she in?
Hello, Mudhami, are you in?
Sorry, I think I had muted by mistake. So as I was saying, I would instruct my advocate to draw a deed poll.
All right. That's your answer?
A deed poll.
Okay. My next question. You've lost your Kenya Certificate of Secondary Education document, or the certificate itself, your KCSE cert. You've lost it. So you've gone to the Kenya National Examination Council at Mtihani House to inquire if you could apply for a new certificate. So they've asked you that it's possible for you to apply or reapply or apply for a new certificate because your previous certificate got lost. But they've also told you that you need to support your application with some documents. So which document is this that you need to attach to your application for a new KCSE certificate?
I would do a verifying affidavit, but if this, but I would say if it was actually and the exact oral question, I would pass. Yes, but I think I would do a verifying affidavit to verify that whatever I'm trying to say is true, that I actually lost my documents. Yes, thank you.
Okay, my second last question. Your client owns a ship and he has entered into a contract with another owner of a ship. So these are two ships at the Indian Ocean. So the owner of that other ship has failed, to live up to his obligations as the contract says. So this contract was entered into while at sea at the Indian Ocean. So a dispute has arisen because the other party has failed to honor his obligations under this particular contract. Which court will you file this dispute? And why?
Where did you say the other party comes from? Sorry.
There are two ships, okay? And these
Yes.
two ships are at the Indian Ocean. They're at high seas, at high seas are, deep into the Indian Ocean. So the owner of this one ship, who is your client, entered into a contract with the owner of that other ship, perhaps maybe to do some, repairs, deliverables, name them. The subject of the contract doesn't really matter as of now. So the owner of that other ship has failed to live up to his obligations. So in other words, there has been breach of this particular contract. So your client has instructed you to file this matter, in court to have, remedies given, or awarded to him. So which court has jurisdiction to hear this particular matter? And I've talked about Indian Ocean, in Mombasa, in Kenya, yes, but which court, has the jurisdiction to hear and determine this matter, and why?
Oh, well, it's called the, can't really remember the first name, but something and Admiralty Court, because it has the jurisdiction to hear and determine matters to do with maritime issues.
Okay, my last question. What are the various ways of attacking a plaint? 3 ways. How do you attack a plaint? Just 3 ways.
Well, thank you for the question. You can choose to admit. You can choose to. Oh, it's a plaint. So you can choose to admit the. Okay, sorry, just a minute to organize my thoughts. But if it's a plaint, first of all, yes, you can.
I just did 3 ways. 3 ways of attacking a plaint. The keyword there is attacking, because a panelist will use, synonyms to confuse you. So I need you to know that. So what are the 3 ways of attacking a plaint? Just 3. Just a word each for the 3 answers. Just a word, and we're done. I gave the chances so longer, yeah. 3 ways of attacking a plaint. Just 3.
Replying.
Mm-hmm. Okay, should we? Sorry?
Just fine. I think what I had in mind is for attacking.
Yeah, but okay, let me just respond. You can reply you can reply to it. You can you can also counterclaim on the allegations of the same. And also you can just reply by admitting to the allegation. Okay.
That's right. Don't worry. It's a learning process. So, Pereno, should I give my feedback or you go and then we'll
No, actually you can give your feedback because there's so many hands. So you can give your feedback, then you do.
Awesome. So I think I'll start with the last question. 3 ways of attacking a plaint. And I've told you, a panelist, even CLE will use synonyms. So unless you know how to maneuver around this particular issue, then it will prove futile for your efforts. So the 3 ways: first, we have a set off, okay? And then you got it right. The second one is counterclaim. And then the third one, you can do a defense. So by set off, because there is also a question on how do you distinguish a set off and counterclaim. So a set off is used as a shield to the plaintiff's claim. So for instance, if you sue me for 200 bob shillings, okay, then I file a defense stating that you also owe me 200 bob, then the debts will just cancel out, hence setting off. A counterclaim, when you look at, I think, the Rule 11 rather, if I'm not wrong, if you have a claim against the plaintiff, the defendant has the option of instituting another proceeding if it can't be settled in the same suit without delay or inconvenience. So that's it. The other question I asked you was about you being a divorcee, okay, and you want to do away with your ex-husband's name. Yeah, you got it right. It's a deed poll. And you have to note, because the next question you'd be asked, how can a person change the name? So in a deed poll, a minor can change his or her name, but through their parents, okay? And then the other instance is when a lady like you, someday you get married and you would like to drop your maiden name and add that, of your husband. And then the last one that I asked you about is when one gets a divorce and would like to drop the name of the ex-husband. So this is normally governed by the Registration of Documents Act, Section 3. And the procedure, you should also read on the procedure, okay? The other question that I asked you was about you losing your, KCC certificate, and you'd like to replace it. And the council has asked you to come up with to support your, application with some other documents. So there's what we call an affidavit for lost documents. Could be lost documents, could be academic, documents, even a passport. So you draft under the Oath and Statutory Declarations Act, you draft an affidavit of lost academic documents. So you'll describe which academic document is this in your affidavit. So it is not a verifying affidavit, okay? That's it. What is the other question that I asked you? Last one. Oh yeah, there are 2 ships at sea, at the high seas in the Indian Ocean. When you look at Article 165 of the Constitution of Kenya 2010, Admiralty claims there's no Admiralty court. It's the High Court sitting in Mombasa that will have jurisdiction to hear and determine this matter. And McHugh, most people don't read on that jurisdiction of the High Court. They assume the High Court only has jurisdiction over interpretation of the Constitution to hear, constitutional violations, original jurisdiction on civil and criminal matters, but they fail to look at the Admiralty claims. And get this, you never know what, CLE will do next. So Admiralty claims or maritime, law claims are always under the jurisdiction of the High Court. So that's where you'll file your claim. So yeah, those are my answers. And I hope you are into your books. But good trial, don't worry.
Thank you very much. Thank you very much, Lavins. Mudhami, you did extremely well. Personally, you passed extremely, passed highly, and you answered the questions. I love the way you answered the questions and how you didn't just pass any question. Thank you so much. Oh yeah, and just I bluffed, like I really bluffed my way in so many things. So never ever worry about anything. I've bluffed. I have argued very wrong provisions of the law even before a lecturer. Na nimesumbuana naye hapo. Yeah, the good thing is having been confident and just supporting your answers. In law, there is no wrong answer, and that is something I've come to realize. There is no wrong answer in law. Every answer is right, provided you can support your answer, your argument. The key issue is supporting.
Also, just a quick one, Mudhami. I think you also need to work on defining your answers. I feel like your answers are generally spot on, like you have really good answers, but please try to define them. By starting to define your answers, that's the only thing I'll insist on today. It gives you a way to arrange your thoughts. Sawa. And then you see that question for the Admiralty Court. You can just say as simple, start by saying, this is a function of the High Court. You see? Then go into, if you can't remember the exact division, you can say, you can talk about the High Court, you can talk about Article, I think 165, on, original jurisdiction to deal with certain matters, because this is a matter under the jurisdiction of the High Court. And then you can mention you're not sure, but you think it's the Admiralty Court. So please work on that. I feel like you always go straight to the answer. And that's a very good thing, depending on if your panel is a panel that's very fast. But remember, you're trying to milk, these things, you're trying to show this examiners that you know what you're saying, and you're trying to maximize on your time. Sawa. The question for deed poll, you've identified it's a deed poll. Tell us more about a deed poll. What is it governed? Which statute governs deed polls? Where is it? Where can I register a deed poll? I think always having more to say will help you generally than having less things to say. Yeah.
Thank you, guys. Thank you so much. I'll do my best to find. Thanks.
You already are.
Did you have a question for us?
Yeah.
Did you have a question?
Myself, yes. Yeah. First, especially on the question of the sea, being a student of the law of the sea and a maritime law, it caught me first because actually I wanted to give a response from the law of the sea perspective, because the way you put it, I first thought you were trying to ask about the jurisdiction of the courts, the jurisdiction of the courts and state sovereignty, because I almost actually said the court that has jurisdiction is the court of the land where these particular ships are registered. So I kind of felt it was too wide, and especially the law of the sea students would mostly respond to that question, basing it on the law of the sea. And I don't think if I answered it that way, I would reach to the same response that you guys expected. Another thing, not really, I'm just making comments on how I felt about the questions. Another thing is that maybe you could next time try to ask us from each class where we've reached on each unit, and then when I come on board to respond, maybe you could try to ask me questions on the point we've reached, because honestly, deed poll, I have just read it for myself. We've never done it in KSL. I'm very sure those people, most of the people maybe have never even heard of it, especially those that did do the civil law. So sometimes people will just be scared of things they've never yet heard of. Maybe you could just take the course outline class ABC, and people can tell you which class they come from. Then you can ask them questions up to where they've reached. Do I have a question?
Mudhami, the problem with that is in the exam, no one will ask you, no lecturer. Okay, some of them will be gracious enough to ask you, okay, where did you reach in your civil, classes, to gauge what you know. So I think now the burden comes with, if you feel like we've asked anything you haven't covered, feel free to tell us that, right? Just tell us, we haven't covered this in class yet. Maybe I would attempt or I wouldn't attempt and pass. because it's just an oral mock. It's just a mock exam. There's no pressure. It's just about to see how you're answering the questions, if you have the confidence, if you have a good format. So there's no pressure. It's not a do or die thing. We'll also try as much as we can to ask first time in second work. But remember, when you're in that panel, the lecturer will not ask you. They won't ask you have you covered this in class, unless that's what they wish to ask. So I think the best thing is let us know in case you feel like we've asked something you haven't covered. Feel free to let us know, and if we can expound it for you after your your mock session. So
yeah, thank you.
okay.
And then I have a question now that I don't know if I'll get another chance to ask. Allow me to ask, but it is not what you have asked me. But because you asked me questions to do with civil, allow me to ask a question on civil. May I?
Yes, please go on. Yeah, go on. It's an open session. Go on, ask your question.
All right. Thank you. So when I read some text on the WhatsApp chat where you guys are trying to talk of pleadings and applications, I expected that when you're talking about the applications, you were also going to speak about the originating summons, but you actually did not talk of the originating summons as either pleadings or applications. So I attended a class where we were taught that OS is a disguised application, but mostly it's used as a pleading. So at the panel, if they ask you, if maybe, I don't know if they can ask, but if they ask you if an OS is an application or is a pleading, which is the safest way to go? Thank you.
Solonka, let me just respond to that. When you ask if an OS is either pleading or an application, just say both, because there are instances where an OS will exclusively be used as a pleading, and there are instances when an OS will exclusively be used as an application. The only applications that are completely like they will never be pleadings. The notice of motion, and you have the chamber summons. But however, for pleadings, like take for example adverse possession. You see, it's a matter that is brought to court through an OS. Okay, so just to be on the safer side, just say it's both a pleading and it's both an application, and by that the panel will know exactly what you're talking about, because there are instances when you'll use it as a pleading and there are instances when you'll use it as an application. And just to appreciate your knowledge in the law of the sea, I like that, and I like that you thought on your feet to know that this is an Admiralty claim, and that's enough. That's enough to earn your mark. Yeah. So that said, Solonka, I think you can proceed before we give LC, Wanjala, and Gitahi some chances to ask questions. Yeah.
Well, thank you for that. Thank you for that. Mudhami, you've passed very greatly, and I really thank you for asking that question on originating summons under 37. So the answer is it's both. There's an OS which are used as pleadings. There's circumstances where it's also used as an application. So you can even check the civil procedure rules. It's provided for under the CPR. There are two different types of OSs. There's form number 26 and there's form number 27. You could go and check on that too. Thank you so much. You passed greatly, and I love your confidence. Now we've asked Mudhami. Now let's go on to Gitahi. So gender equity, girl, female, male. So Gitahi, are you here with us? Quincy. Hello. So maybe we can go on to Dulo. Dulo, are you here with us?
I'm here.
Okay, so I'll ask you a few questions, then later on you get back. You can ask questions if you have any. Is that agreeable to you?
Sure.
Okay, thank you so much. Thank you so much. Okay, now moving straight to a point. What are the three ways in which you can respond to an application?
There are three ways in which you can respond to an application in accordance with Order 51, Rule 14 of the Civil Procedure Rules. You can respond to an application by filing a replying affidavit. The replying affidavit is an affidavit whereby you explain, you as an advocate, when you draft the replying affidavit, or actually it's sworn by the client. So the client gives his version of the account by responding to each and every ground that has been raised in the application against the client, against the person who's swearing the replying affidavit. The second way in which you can respond to an application is by filing grounds of opposition. It's actually quite simple. Most of the time, it's a one-pager, whereby the advocate just states the grounds on which they shall oppose the application during the hearing of the application. Then finally, you can also respond to an application by filing a notice of preliminary objection, which is usually based on points of law. Points of law such as matters to do with jurisdiction, res judicata, res sub judice, locus standi. Yeah. Also, you are basically notifying the counsel for the applicant that you shall oppose the application based on the specific point of law. Thank you.
Thank you very much. Thank you very much. Excellent. Now, moving to the second bit of your question, you've mentioned replying affidavits. What's the difference between a replying affidavit and a supporting affidavit and a verifying affidavit?
Thank you for the question once again. A replying affidavit, as I had mentioned before, usually the deponent is responding to allegations or the grounds that have been raised in a particular application. So it's basically a response based on what has been alleged in the application. This is my response to it. And then a verifying affidavit. A replying affidavit is one of the ways in which you respond to an application. A verifying affidavit usually accompanies a petition and a plaint, and basically and even an election petition. And the purpose of a verifying affidavit is to verify the truthfulness and the correctness of the issues that have been raised in the document that it accompanies, whether it accompanies a petition or it accompanies a plaint or it accompanies a winding up petition or a bankruptcy petition. Usually the purpose of a verifying affidavit is just to affirm the correctness and the truthfulness of whatever you have raised in the pleading that it accompanies. Then the final affidavit is the supporting affidavit. A supporting affidavit, more often than not, it accompanies a notice of motion application. And the purpose of a supporting affidavit, and it also accompanies a constitutional petition. So the purpose of the supporting affidavit is
thank you for that.
So the purpose of a supporting affidavit is to adduce evidence. Usually, whenever advocates draft, the deponent swears the supporting affidavit, they are adducing evidence from the supporting affidavit just to support what they have alleged, what they've alleged in the application. Thank you.
Thank you very much for that. Thank you very much for that. Now, next bit of the question is, you're familiar with the term prima facie. So what's the difference between a prima facie case in criminal matters and a prima facie case in civil matters?
The basic definition of a prima facie case, based on my understanding, is a case with high chances of success. And I think that is mostly applicable to civil matters. As for criminal matters, I stand advised by the panel. I am not very conversant with that. Thank you.
Most obliged. Now, what are leading questions?
Leading questions are questions that are asked during either examination in chief, cross-examination, or re-examination that basically lead the witness box to answer either yes or no. Most of the time, leading questions take the form of to be, that is, did you see this happening? Can you do this? Most of the time, the answer that is expected is either a yes or no answer. Leading questions are basically forbidden during the adduction of evidence, of the viva voce evidence, during the during trials, save for cross-examination. According to Section 150 of the Evidence Act, leading questions may be asked during cross-examination, but may not be asked during examination in chief and re-examination. However, leave of court must be sought for an advocate to ask leading questions during the examination in chief and the re-examination at the re-examination stage. Thank you.
Thank you very much. Come to the end of my session, and be honest, you've done extremely well. Extremely well. I loved how you've answered the questions. You really paired up the law. You paired up the principle. Just yeah, how can I say? I'm really impressed. Really impressed. You did very well. So you answered all the questions rightly. Prima facie case, you answered it correctly. Now, when you're answering, or after you've given your answer, the principle that you gave, you can now mention. There's that case I had just cited earlier on. Brown versus First American Bank. You could cite that one there. Now, in regards to criminal cases, a prima facie case in criminal cases was well defined in the case of Bat versus Republic. You can get it in Kenya law, Bat versus Republic. And this is basically a case where a reasonable tribunal, properly directing its mind to the law and the evidence, can convict even if no defense has been entered. Yeah? That is it with regards to prima facie case in criminal cases. It's where a reasonable tribunal, after the prosecution has given its case, can properly, and after directing its mind, convict even if no explanation has been given by the defense. So I'm not sure if you've gotten there, but we'll get to that point in criminal litigation. So to me, you've
Thank you
passed
so much.
Karibu sana. Now, Muturi Andrew.
Maybe additional feedback. Again, you did amazing. Really nice. I like how you had a really good grasp of the law. Lakini, I want you to do something. Whenever you're answering a question, like the one for prima facie, if you don't know what it means to criminal, stick to what you know. Sawa, because you see, when Brian was asking you that question, he didn't tell you to define a prima facie in both civil and criminal. He just told you to define a prima facie. You see? So
sorry, I asked prima facie.
Oh, you asked for both?
Yes.
You said in the law, right?
I say distinguish between in criminal cases and in.
Oh, right. Okay. So sorry. In that sense, then that you answered well. Another thing I wanted to say, when you see like there's a question you're answering, I think it was the first question or the second question. You were speaking about a couple of things. There's this trick we were taught like when we were preparing for orals. If you know that you're about to maybe mention a couple of things, and you hope not to take or lose the attention of the panel, you can number them. So you can say, for example, I can't remember the question you were discussing, but you can say something like, for example, if the panelist asks you, maybe name 5 instances where you can use a petition. So, and you've already defined, inside by saying this is a petition is ABCD. A trick or a tip you can use, especially when you know you're going to go into defining, is by starting to number. So you can say number 1, an election petition, and say an election petition, is governed by the election laws. Then you come again. Number 2 is this. That way, you first of all, you're keeping a mental checklist of things you need to answer. But number 2, you're also not trying to lose the attention of the panelists. So I think the question was in regard to attacking. Was it an application that way? So start by labeling them. You can start by saying, for example, there are 3 ways, and then name the 3 ways, and then start explaining the 3 ways. Or you can name one, explain, name another, explain, name another, explain. But when you begin to answer, create that checklist. Tell them, for example, I'll be discussing the 3. The 3 are number 1. That way, when number 1, you're keeping a checklist of what you need to answer, but number 2, you're also not losing the attention of the panelists, because as you continue to explain one way, you might remember a case law, you might remember more information on it. And again, remember, you're trying to milk these things. It's a 10-minute thing. It's very underrated. So in those 10 minutes, you need to make sure you've impressed them, you've shown them you understand the law, you've answered correctly, and of course, you're having their attention throughout. Other than that, excellent, good confidence, good tonal variation, everything was on point.
Thank you so much, Ms. Abdi.
Karibu sana. Now, Noah, is Noah in the meeting?
I'm alive. I'm alive.
Okay, so take Muturi Andrew.
Muturi Andrew, kindly unmute your microphone. Are you there?
Yes, I'm here. Although you're not audible, but I can hear you.
Okay. Can you hear me now?
Yes, I can.
Okay. I have certain questions for you. I hope you'll be able to answer them. I pray. So my first question is an application question.
Okay.
Let's assume Alex is a chief magistrate now, let's say in Kisumu, and then he has already, started his session exactly 8 in the morning. Now, the moment files are being called, Mr. Pareno, unfortunately or fortunately, comes running to court, and then his file is being called immediately. He enters. Now, let's say that it's a criminal case, R versus particular Vince and 20 others. Now, before the file is being, before the clerk finishes calling the file, Mr. Pareno stands up. He rushes up in a pink suit, says, Your Honor, Your Lordship, sorry, I think this matter is coming up for hearing today. Mark my words carefully. I think this matter is coming up for hearing today, Your Honor. Then he proceeds, in the course of his, assertions, he proceeds to make a joke, which all the other counsels are laughing, except the judge. So my question is, what are the rules of etiquette that Mr. Pareno has breached?
Yes, thank you for that question, although I didn't get the whole question fully, but what I've noted, you have mentioned there is the dressing code, the kind of suits you're supposed to wear when you appear in before the magistrate or before any court. Of course, you cannot appear when you're in a pink suit. And then number two, the fact that he said that I think this matter is coming up for hearing today, I feel like there is not, he didn't observe etiquette in terms of the way he addressed the judge, sorry. And also, I feel like he should have at least addressed him properly and in a manner that would have even maybe would have convinced the judge to recall the matter. Thank you.
Fair enough. My second question is, what are the principles of granting bail?
Okay, thank you for that question. The principle for granting bail, number one, the court will consider the nature of the case in terms of how serious the case is. And also the court will consider whether the accused is a flight risk. The court will also consider whether the accused had previously been accused and was given a bail and he absconded. And then also the court will consider whether there is likelihood of this accused person interfering with evidence and also interfering with the witnesses. Thank you.
Okay. Kindly distinguish between inhibition, caution, and restriction.
Come again?
Kindly distinguish between these three terms: inhibition, restriction, and a caution.
Thank you for that question. I'll start with the caution. A caution is placed on a parcel of land at the land registry. It's registered at the land registry to preserve or to prevent any dealings on that parcel and to maintain, in a way, to maintain the status quo. That is to say, that parcel cannot be transferred or sold to someone else, whereas that caution is still or it has been registered. And the same case applies to a restriction. But now a restriction is placed by can be placed by anyone who has interest on that parcel of land. For example, someone who bought a parcel, and then in one way or the other, there is a case that is pending in court, and he feels like the person who, the seller, may proceed to sell the parcel to another person. He can proceed to register a restriction at the land registry to prevent any dealings on that parcel. An inhibition, on the other hand, this one I start guided. I can't quite remember, but I believe also it serves the purpose of prohibiting dealings in land, especially. The same is also registered at the land registry. Thank you.
Okay, my last question is a commercial question. What are the primary differences between a private company and a public company?
All right, thank you for that question. Private company, number one, the difference is for a public company, it's open for members of the public to subscribe for shares. Whereas in a private company, it's limited. You cannot, members of the public cannot, it's not open for the members of public to buy shares. And then number two, it's on the name. For the private company, it will end with the name, of course, private company. And then for the public company, it will end with the name public company. And then number three, it's on the number of directors. At that point, I can't quite remember it very well, but I think on the number of directors, there is that difference. Thank you very much.
Mr. Pareno, that's all I have for him. Unless there's any.
Thank you very much. He did exceptionally well. So you could give him his feedback. You could give him feedback on that.
Okay. Mr. Andrew, you did very well. So with regards to the 4 questions that I've asked, the first question I asked because I just remembered abruptly, it came in our exam, the CLA exam. So my advice to you when such an application question comes, especially in trial advocacy, you have to be very careful when it comes to issue. It might seem a very easy topic, this issue of etiquette, but when you see such a question, read each and every sentence with precision, because you'll realize that each sentence has a point. Like I said, the magistrate began before Mr. Pareno walked in. Now that's an issue of punctuality. Then we also have issue of mode of address. Instead of saying Your Honor, he said my Lord. Then issue of mode of address. Then issue of when you are making a joke or when you are practicing humor in court, you must involve the judge. So each and every sentence has a point. Then number 2, the question number 2, principles in granting bail, you did well. And I'll refer you to the following cases so that for your further studies. The first case I have is we have the first case is George Kamau Nganga versus Republic. It's a good case in establishing the principles to consider when granting bail. We also have Muite versus R. Then we have Wainaina versus R. Those 3 cases are very important when you are discussing the principle or the factors to be considered before granting bail to an accused person. So those are the 3 cases. Then issues to do with the conveyancing part of the questions I asked, kindly read section 68 to 78 of the Land Registration Act. it will give you the three distinctions, and then also you read the regulation. Think legal notice 278. I think Pareno said this in our introductory class. 278 and 280, kindly familiarize with those regulations. Then the last question I asked was, what was the last question I asked? Don't think, can remember.
The difference between and private company.
Oh, private and public company. A quick distinction. One, you also the first issue you have to look at is membership. Number two, you okay, me personally, how I used to answer my question before the panel is when I'm being told to differentiate two or more issues or topics, I normally give them some subtopics. Like if I'm being told to differentiate between a public and private, first I have to take a pause and internalize the question. So I'll look at it in this way. The first issue is transfer of shares. You realize in public you can easily transfer your shares as opposed to private where it is restricted. Number two, issues to do with invitation to the public to subscribe. You realize in public it is easier. You can invite the public to subscribe as opposed to a private. Number three, issues to do with membership. When we talk about private, it is a bit limited, I think, to 50. Then there is no limitation of members in a public company. So when you are answering a question, have some logical thought. Internalize first, don't be in a hurry. Have time inside there to think. Then you'll be able to. But I'm very happy how you answered the question. I also noted some things that you said, and I think today I'm very happy with how students are answering the question. That's all.
Thank you very much. So it's actually at 11 o'clock, so maybe we can finish up with Danson and Wanzala. Then we'll pick it up. So Danson, are you in?
Yes, I'm in. Can you hear me?
Yes, I can hear you.
Okay, very well. Carry on.
Maybe I can I'll ask you two questions, then Labinch will ask you two questions.
Fair enough.
That's fine, huh? Okay, so now we can begin. What are third-party proceedings? And how are they used? Yes.
Thank you very much for the question. Third-party proceedings are provided in Order 3. If I'm not wrong, I'll just confirm that. And this is where a defendant, having been sued, indicates that indeed there's another person who bears liability, either as a contributory to that claim or out of indemnity. So I think that is how you then, but then of course you need to seek the leave of court, and then the court will grant you to leave to be able to add on a third party. Thank you.
Good. Perfect. Now, my next question will be, what are the different types of pleas in a criminal case?
Sorry?
Different types of pleas in a criminal case.
Oh, please. Yeah. So thank you very much, Bonapareno, for that question. One, of course, is the plea of guilty, or you say where you admit the facts, and indeed that one, the same is entered in the record. The second one is a plea of not guilty. This is where then you indicate that this plea is that you actually refute all the facts. And for both, it has to be equivocal and clear, because any ambiguity in plea taking then renders the whole process a bit of a challenge. And this was, I think, held in on appeal in Adan VR on the process for plea taking. And then the third one, you can plead ultra force. It's called where you can then indicate to court at that preliminary stage in Lima that indeed you had been convicted of a prior offense, or you've been acquitted of a similar offense. So I think those three can then address the issues of plea. Thank you.
Thank you very much. Thank you very much. For me, you've answered all the questions perfectly. You've done well. That party proceedings, you've gotten the principle very right. And the only thing that I would maybe add or comment on is it's under order 1, rule 15 of the civil procedure rules. And that's all. You've done it perfectly.
Thank you
Keep
very
it up. Now I have Vince.
Thank you. Danson, how are you?
I'm okay, Patrick. It's good to see you this evening. Thank you very much.
Awesome. Awesome. So, what is considered the fourth arm of the government and why?
Now, thank you very much for that question. And indeed, for me, I consider that to be a big fallacy, indicating that indeed there's a fourth, even conceptualizing that there's a fourth arm, because this has been tasked to constitutional commissions based on their nature of how they operate. Indeed, they are to check the executive, but then there are so many constraints that affect that concept, because then their work and their ability are first controlled by executive through appointments, through budgets, and even control of their affairs. I think that, in my view, then does not exist other than as a fleeting concept. Thank you.
Amazing. What are the five types of bail?
Just come again, sorry.
Name 5 types of bail.
Bail. So based on the judiciary guidelines on bail, we have bond being part of bail, which then, of course, it's actually where you encumber certain either person or property for that matter. There's also surety, where somebody stands in for you, a person of good character, and he has to show up in court to indeed indicate that they can give surety. There's also, of course, cash bail, which then it means it's a deposit of funds in court for that matter. There's also what you call a free bond. This is where the court will expect you to show up whenever needed, and there's some level of assurance, and mostly this is granted to persons whom the court feels that they're obligated to show up in court either as public figures or like, for example, Philomena Mwilumbete was granted free bond. And then there's also something called cognizance, which is almost nearly a free bond. Thank you.
Amazing. Good trial. With my first question, our constitutional and independent constitutional commissions and independent offices are considered the fourth arm of the government. And like you said, whether it's a fallacy or not, that is rebuttable, presumption. But it's good that you brought that distinction. And then on my last question, the types of bail, yes, what you've said is correct. But in an exam setup, in an oral exam, what you'd say, you have anticipatory bail. Of course, bail carries different dimensions. There's cash, there's what you mentioned, that if it were in an exam setup or in an oral setup, you can start with anticipatory bail. There's police bail, there's bail pending appeal, there's bail pending trial, there's also bail pending judgment. So I think you understand what I was trying to say, but what you've said is correct, yes, but you could highlight them under the 5 main categories of bail. I hope that's okay.
Correct. Much appreciated, Patrick. I really appreciate it.
Awesome. Great. You did well. Keep oiling the wheel, and I wish you the best. Yeah, so back to you, Solomon.
Thank you so much, Patrick, and indeed for the trip. Thank you.
Awesome.
Thank you very much. You guys, you did extremely great. You've answered questions well. And then we'll be having more of these sessions. Now, since I can't see any hand up, there's a suggestion that some of my colleagues had, because now we usually have over 200. Okay, today we had yes.
Sorry. My hand has been up since, but I think there's someone who is lowering my hand. Someone was
sorry.
So I don't know. So I don't know if time is up. Maybe.
No, it's not up. It's not up. Your hand was up. So Caroline will kindly ask you a question. She's one of our colleagues.
Oh, okay. Yeah, I'm good to go.
Okay, no problem.
Hello.
Hi, Caroline.
The first one, how do you proceed when a minor is a party to a suit?
When a minor is a party to a suit, first of all, they are sued in the name of the parents or a guardian.
Okay. The second question. What are the qualifications to act as an advocate in Kenya?
You must have you must have gone through the LLB program, that is the Bachelor of Laws degree at the university level. And then you must have undertaken the advocates training program and a pupillage program. And then after all that process, you can petition the Chief Justice to be admitted as an advocate to the High Court.
Okay. Then the third one. What are the 3 remedies you can ask for in a judicial review?
You can ask for an order of mandamus. You can ask for an order of certiorari. You can ask for which one? I forget the third one.
Okay.
Yeah, I've remembered those 2. I've forgotten the last one. Sorry.
Okay. Next, the final question. Let's say yes. I have property, not property.
Yes.
I have goods with me.
Yes.
And 2 people are fighting over those goods. I'm not interested. I have no ownership in the goods. How do I proceed? I'm not interested, but 2 or more people are interested in the property.
You institute interpleader proceedings.
Okay, how do you institute this in interpleader proceedings? What pleading? What document? Yes. Sorry, what document do you do? What document do you do to initiate these interpleader proceedings?
I think the application. I think the application will be chamber summons, and then you will have an affidavit and a list of documents. Okay. Yes. Thank you.
Okay, we finished there.
Thank you.
Parano?
Thank you so much, Carol. Thank you so much, Carol. So Carol is actually one of my friends who used to teach me accounting. And when you get to that point, I'm sure she'd be really glad to help you. Accounting is one of the challenging units in challenging topics in LPM. So I'm sure she'll be of much assistance. Carol, do you have feedback for her? Personally, she did extremely great, extremely great. Other than the JR question, the last one is what? It's prohibition, an order of prohibition. Other than that, Carol, do you have comments for her?
Thank you. Thank you so much.
Yes, she did great. Just to clarify some of the sections. When a minor is a party to a suit, if the minor is the one suing, she or he will sue through an ex-friend. Then if they're defending, it will be through a guardian ad litem. Then qualifications to act as an advocate in Kenya, there are normally 3. You have to have been admitted to the bar. You have your name has to be for the time being in the role of advocate, and then the third one, you have to have enforced a practicing certificate. And then Pareno has clarified the JR one. The third one was prohibition. And then in interpleader, when you're initiating the application is through a notice of motion. If you're doing the interpleader when other proceedings are ongoing, you use a chamber summons. Okay, Pareno, I think.
Thank you so much, Caroline. Where it's noted. Thank you so much.
You're welcome. So you've all done exceptionally well. So next time, what you can do, because I've realized you guys have you have a lot of questions that you want to ask us before during the week. Maybe interactions in class or group work or project work, you could come up with a list and then you can dedicate maybe the first 1 hour to answering your questions and maybe discussing areas that you need some clarification on. And then now the rest of the hours, we do the oral mock-ups. After orals are done, we will now start doing past paper questions to show you how to answer and go about the questions. Now, there was a suggestion by one of my colleagues that we should have maybe concurrent meetings so that we have maybe fewer numbers in each meeting, and then most people can get a chance to contribute. What do you think about that? Are you agreeable to that? Should we just keep up with the same, with what we've been doing so far, or you want maybe different sessions. Maybe you can have Sumaya and Caroline in one session, me and Lavins and Alex in another session, and so forth. What do you prefer, or what are you guys agreeable to? So at the same time, even if we're the one who are conducting these things, we're here to help you. And the best way, or we'd be glad to take up any way or any method of doing this thing, the oral mock-ups and the mentorship program, in a manner that benefits you the most. So we would love to hear contributions. Go on, Mudhami, then we go on to Muse Hedwig, then Wanjala Sophie.
Thank you, Pereno, for the opportunity. I think having two groups will not bear much results because the questions that you guys are asking the other side are not the questions that other panelists are asking this side. So either way, people from this side will miss what is being asked from the other panel. I feel it's better when we are all here, because even if we ask, you guys just get an opportunity to ask 2 or 3 people questions and you go ahead to clarify the same. I feel it's beneficial to all of us, and I feel we are still learning. Yes, thank you.
Thank you for that. Thank you for that, Mudhami. We can go to Hedwig. Please go on. Then Wanjala.
Thank
Brian,
you.
just a minute on that. I think that's a really, good point she has raised. But looking at it on the other side, the pro of having different groups means that number one, we'll be recording all the meetings, so all of them will be available on YouTube. But also the fact that we see we are all over 200. So that means that only by the end of our exercise, only like about 10 or 15 or even 20 of you would have spoken. And then everyone else doesn't get to actually do the oral prep. That's a disadvantage. You see, with smaller groups, if you have like 4 or 5 groups running, at least more people will be able to speak. And you have noticed, even you presented today, right? After you presented, this sort of like confidence you get, and this form of like, you've understood the correction, you've seen your speed, you've seen your tonation. And honestly, to be honest, all these questions that we're asking are already on the oral documents you've sent. So I think for me, oral prep is not all about the questions. It's more of, are you answering correctly? Is your intonation fine? Is your speed okay? So I think it's more than that. And I feel like the advantage of having many groups is that then more people will be able to answer, which means more people will be able to gauge themselves and see what they need to work on before the exam. So think of it also in that perspective. But if we do, end up deciding on having one group, no problem, we'll record. If we end up having two or 3 groups running at the same time, we'll also record. And I'm sure in between the week, it can be a good listen for you guys. You can just watch it in between the week and just listen to and know how other people are performing. And even by that way, you're able to critique other people's performance and improve on yours, right? So I don't know. Maybe you can also think of it from that perspective.
Yeah, that's fine. That's fine. Now, maybe other guys can give their contributions. Muse.
Okay, thank you, Brian and Sumaya, for the comment. While the views of Sumaya are good, I still feel we should maintain this group. At this time, we're around 200, and I think it's still manageable because we will want to miss some of you, the team, because you have the beauty of diversity in the way you approach your comments, in the way you ask questions. So I still feel we can move on with this unless it's overwhelming, then we can divide. Thank you.
No, on our part, it's not overwhelming at all. Whatever you guys decide, that's what we're going for. So it's up to you guys.
I suggest we maintain this. Thank you.
What about you, Nyabil?
Good evening, guys. I'm sorry, I hope you can hear me. So my point is we can maintain this one because of diversity, but we can also add the number of meetings so that at least everyone can get a chance to, get grilled by you guys and learn something new.
because I'm sure like today a lot of people have learned something new, especially those who didn't do law of the sea, and those people who hadn't gone that deep into civil to know about deed polls and things like that. So I think we can maintain this, or and still I think Miss Omar had a very good idea too. But my major point is we can add the number of we can maintain this one, but add the number of meetings, like 2, 3.
Yes, that's totally fine. That's totally fine. Thank you so much. Kamala?
Good evening, guys. Sorry, I had a problem unmuting. First, I would like to agree with Diana that if it's possible to add the number of meetings per week instead of dividing the groups, I would really suggest that we maintain one group for the sake of diversity, for the sake of learning from all of you. Now, the problem with Sumaya's suggestion of recording is that at KSL, the volume of work is crazy. So during the week, someone can barely have time to go to the recordings because we have the project work, we have the assignments, we have readings, our own readings to do. So it is just crazy to have, it's almost not possible to have time within the week to go back to the recordings because there are even other classes someone might miss, and so they're forced to go back to listen to them, and that's like 2 or 4 hours. So I would really suggest that we maintain this group for the sake of learning from all of you, but maybe we increase the number. I don't know if it's possible to increase 2 to 3 sessions per week. Otherwise, we really, really appreciate your assistance. Thank you.
Okay, thank you. Thank you, Kamala. I think Solonka dropped off, but I think the one person has their hand raised. Musa, maybe you can go ahead.
Sorry, Sumaya, I've already spoken. Let me just lower the hand. Thank you.
Okay, I don't think I see anyone else hand up. Oh, sorry, Wanyama Veronica.
Sorry, are you able to get me? Am I audible, Sumaya? Omar?
Yes, Mama, we can hear you.
We can hear you. We can hear you well, Veronica.
All right, thanks. So on the suggestion about increasing the number of meetings, there is only one fault in that there are some people who have evening classes actually, which start from 8. And then you find that morning classes end at noon, and then afternoon classes pick up from 2 to 6, and then evening classes begin from 8. So when we talk about increasing the number of meetings, it must be detrimental to those people who have weekday classes, because I'm sure they'll also want to attend the meetings. And I think I will go more with Sumaya's suggestion in that meetings to be maintained on Saturday, but since we want more participation and more people to have experience, then maybe we have like 3 panels per meeting, or so that as much as those other meetings are being recorded and you can get to it at your own time, but more people are able to get the experience on what orals is about. Because like last week we started from 8, we ended at 11, and we actually only had 5 people. So if we could have maybe, that is my personal suggestion, so that all of us can get into the discussion. And I think the basic point of all these orals is to get those remarks and to build on confidence. So I'm feeling like if we really subdivide, we may really build on that.
Yeah. Okay, so guys, I think first of all it's getting a bit late, and I think most of us need to sleep and that. So I'm just going to give everyone else who's raised their hand a minute to speak. But what I'm going to do is I'm going to create a poll. I'm going to create a Google link tomorrow with just a question with the questions, and then we will share them on the group, and then you guys can insert your comments, and then we can see how to go from there. But I think so far the overwhelming majority is that you want to maintain one group, and I totally understand. They both make sense. So I think it's just up to us to weigh. Do we want to learn more from the fact that we're a diverse group of different people, or do we want more people to practice their oral skills? So I think we will just have to decide that, and I'll create a Google question sheet, and then everyone can answer, and then we see how to go from there. So, but in the meantime, I think, does anyone want to say anything that hasn't been said? I think Ogola, Esperance, and Isaac Johnson had their hand up. Maybe Ogola, Esperance can go first, and please, 1 minute max. Let's close the meeting.
Hello, Mzabdi. Can you
Hello,
hear
hi.
me?
Yeah, we can hear you. Go ahead.
Okay, first I want to thank you and your team, Pareno and Patrick, for the good session that you are having. And secondly, I'd say that I'd suggest to just move as a group, because we get to learn a lot of things from each of you, because all of you come with different perspectives, and that is good for us. And thirdly, I want to say that we can increase the number of meetings per week, because even those who have their evening classes, their classes ends at 7:30. So if we begin at 8 or 8:30, it will be still beneficial to them. So it's a good suggestion.
Okay,
that
guys, the thing with the different meetings, we have to consider a lot of things apart from the fact that the evening classes. We need to consider that even as we are pupils, we're currently doing our pupillage, and we only have the weekend because we work from Monday to Friday. So first of all, weekdays are going to be hard for us to commit. And then for the weekends, it's the only time we get to do things, go out, spend time with family. So I think also having, more than one meeting, because our meetings last from around 8 to 11, right? So I think having more than one in a week will also overwhelm us as pupils. But I don't know if you guys can also come up with an agreeable time. Maybe we can reconsider. And that's why we were thinking of splitting the groups, because with the splitting of the groups, we'd have maybe a session on Sunday and a session on Saturday, because we can split the groups and take the different times. But that is also something we need to consider. So there's a lot also. It's apart from the students who are in class G, there's also us. We also need to consider our schedule. I hope that also maybe shed some light. I think we can have Isaac, and then I'm seeing Alex has his hand up. Isaac, then Alex, please, 1 minute, and then we close this up.
Good evening, team. Most of what I wanted to say has been said. I just want to thank the group who have committed to come and help us. You are sparing your time. You are taking your time to help us. I want to thank you so much. And I think we are going somewhere with your assistance. God bless you. God bless you so much. Thank you.
Okay, thank you. Alex and Henry.
Okay, can you hear me, Sumaya?
Yeah, go ahead, Alex.
Okay, thanks. So mine was just a comment about from my observation from the questions which you have asked. I have noted that let me not say most, but some of the people who have asked questions after we have given our feedback have not really considered our what we advised. For example, there's a time you say, Sumaya said, if you are giving an answer, try to break it down so that you cannot lose the panel. Like like say, there are 3 ways of responding to an application. 1 is through a replying affidavit. 2, grounds of opposition, like that. So some of these things which will tell you, try to incorporate them in your. If you come next after the person has spoken, just listen. If you can, just note down just confidence, dress code, and stuff, so that it can be a beneficial exercise for you. If you get a chance to be asked questions, try your best to incorporate what you have heard from the advice you get from different people into how you answer the questions. And I think that's the only way you'll be able to benefit from this exercise. I think that's all I want to say. I hope you take it into consideration, and I hope you have found the session beneficial to you. Thank you.
Welcome, Alex. I think we can have the closing remarks. There's something that I think Henry had his hand up. Henry, we can hear from you, and probably close. Yeah.
Okay, good evening. Thank you so much for taking your time to guide us through. I really appreciate. So my name is something else. There was a group that we have seemingly failed. Personally, I have received a link to I think the that group that is full. So I'm simply requesting.
I'm sorry, Henry, I can't hear you. Please, maybe get closer to your mic.
Okay, so can you hear me now?
A bit better, yes. Continue.
Okay, saying thank you for taking your time to guide us through. Mine is a concern. The WhatsApp groups are failed, and I personally received a link to that group, but it failed. So I'm requesting, is it possible we can maybe have a Telegram group? It will accommodate more people, and for uniform communication. I have heard reference being made to materials being sent to the WhatsApp group, and some of us may be missing out. So if it's possible, we can maybe have one large Telegram group so that it can accommodate all of us. Kind request. Thank you.
Groups. We're currently on our fourth WhatsApp group. So maybe send me a chat on Teams. Just go to my profile, send me a message. I'm going to send you the link to the fourth group so that you can join. But this is the thing, like most of us, I don't know if there's any of us here, the tutors or the mentors who use Telegram. Maybe I'll speak to them and you can see who can volunteer to, because I can open a Telegram group, but I'm not active on Telegram, and I don't want some information to get lost on the way. So I'm going to send you the link for the fourth group. Please join that one and share. And also, guys, if you're in more than one of the groups, please kindly leave so to give people space to join. But generally we found the Telegram group a bit hectic because people were not able to, most of us don't use the app. So once you don't use the app, then it becomes hard to communicate on such a platform. But what we can do is, Henry, since you suggested that, maybe you can open a Telegram group and I will add you on the 9Ps, the fourth group. And when you see any information sent to the group, you can forward it on Telegram. Is that fine?
Okay, that's fine. Thank you.
Okay, perfect. So just text me on Teams and then I'm going to add you. So I'm going to send you the link for the fourth group. And please, guys, if you're in more than one group, please kindly leave, because as you've seen, we share the same information across board. So you're not going to lose on anything. So. Okay, so I think without further ado, I'm going to end this meeting here. We have the groups, we're going to talk. I think we've had a really successful day, and thank you so much, guys, for showing up. And yeah, all the best in your projects and your orals, and yeah, everything will be okay. Don't stress. You guys are definitely going to all pass. So I think we can close it from here. Have a good night.
Yeah, awesome. Good night, everyone, and feel free to reach out in case of anything.
Good night. Thank you.
Good night. Thank you.
Good night. Thank you. Thank you.
Night.
Good night.
Good night. Thank you, guys.
Karibu.
Thank you.
Anteni sana.